Upon notice, your lordship stand leave to mention my lord, a review application.
Review
Application of your lordship.
upon notice.
With notice I am mentioning new motion group one, my lord. My lord,
may I to mention for upgradation.
Upon notice.
my lord, may I pray, my lord, leave me lord, to file contempt application order in the my lord sitting in Jalpaiguri circuit bench, my lord.
Motion.
Department is same, otherwise leave without leave we can take out the matter, ma'am.
First time.
Kindly, leave may be granted, my lord.
No leave necessary. It's my order.
Yes, my lord.
No leave
My
necessary.
lord, my lord was sitting Jalpaiguri bench, my lord.
File করছে leave লাগবে না জলপাইগুড়ি order. No, I don't
My lord,
think.
department is saying, my lord, until leave is granted, we can't take.
Because my orders contempt will of course lie in this court. No leave is necessary.
Jalpaiguri circuit bench, my lord. Yesterday, they refused, my lord.
জলপাইগুড়ি সার্কিট বেঞ্চে আমার অর্ডার তার এগেইনস্টে কন্টেম্প ফাইল
লিভ লাগে না মাই লর্ডের
অর্ডার হ্যাঁ হ্যাঁ বলুন তো ডিপার্টমেন্টে বলুন I look into it. No leave is necessary.
My lord, may I be permitted to mention item number 349 of the list dated 9th October 2023 for upgradation. This matter relates to unauthorized enforcement made by the private response.
Take upon notice.
Yes, my lord.
Lordship, may I be permitted to
mention one motion matter for upgradation?
মাই লর্ডের অর্ডারে লাগবে বলে
I have served upon notice I am mentioning.
আমি খবর নিচ্ছি
Yes.
These I have mentioned on my lord item number 617 where your lordship was supposed to direct the matter to appear 9th October. My lord, at that point of time the BH was not sitting, it is running in the list item number 617. I'm praying for upgrade upon notice.
Upon notice.
Upon notice.
My lord, may I mention a matter?
And inclusion in the combined list, listed motion. Without notice, my lord, the I've served. Land government.
In the combined list.
In the combined list, I want to inclusion in the combined list.
My lord, may I mention a matter?
Combined listed হবে
Combined list. This is combined.
My lord, it's a residuary matter for inclusion, new motion. The
This code doesn't deal with residuary matters.
Yes, my lord.
This code doesn't deal with residuary matters.
Upgradation to. No.
May I permit to mention combined listed খালি
Combined list.
combined listed হবে
Combined list. I have not.
my lord may I
My
mention
lord, may I permitted to mention, my lord, for contempt application?
contempt application? Yes. New contempt?
Yes, my lord.
Yes.
Not deposited with the right as they are not direct.
You're mentioning upon notice?
Yes,
Lordship, may I be
You're only asking for releasing the amount for the present. To be mentioned.
My lord, may I mention for inclusion list?
You're mentioning upon notice to the other side? Yes, ma'am. What is your urgency?
Inclusion motion, last order say that after vacation, 1 week,
It's a hearing. Motion.
Mention for release.
your lordship may. This is a withdraw matter, your lordship. We are withdrawing,
withdraw?
serve notice to the other side, your lordship.
To be mentioned withdrawal.
Lordship, may I be permitted to
To be
mention?
mentioned withdrawal.
To be mentioned, withdrawal.
Be permitted to mention one motion for upgradation, Lordship. I have served upon notice I am mentioning. Lordship.
Yes, all the days visits.
এই জলপাইগুড়ি লিস্ট তো ও জলপাইগুড়ি হবে পাঁচটা পেজ নম্বর 30
Contempt matter. তার আগে to be mentioned এগুলো দেখো তার আগে বলো
তুমি বার করো এই কারুকে পাঠিয়ে দে আইটেম 1 না রেগুলার লিস্ট আইটেম 1
Lord, I am for the petitioner. This matter is appearing for extension of interim order. My lord will find from the record that on 4th of July 2022, there was a first direction for filing affidavits by the state. My lord, despite repeated opportunities, my lord, till
not
date-
file
Because they have, my lord, in that matter, they have challenged the virus, my lord. We have prepared an affidavit and it was submitted before the learned advocate general, my lord. But the situation is we have not yet.
You have to
Just-
wait for some time, let the interim order be extended.
Yes, my lord. And
That event, my lord, I'm just making one humble submission subject to my lord's kind sanction. Let this interim order be extended till disposal, my lord. Because my lord will appreciate my
Be
my lord, one
extended for some time.
great.
Let it be extended till February.
Great. Great.
Affidavits are yet to be exchanged. Paragraph. Since the interim order granted earlier expires on 30th November 2023, comma, the said order be extended till 29th February 2024 or until further orders, comma, whichever is earlier.
I'm deeply obliged. Grateful.
my lord, the time to file affidavit may be extended.
On prayer of
My lord, this be made, my lord, peremptory for the reason my lord
state
spoke.
respondents, comma, liberty is granted to the respondents to use affidavit in opposition within 2 weeks after the vacation, within 2 weeks after the ensuing vacation.
I'm deeply
Stop
obliged.
affidavit in reply, comma, if any, comma, be filed within a week thereafter.
Grateful.
I'm grateful.
What is in the interim order? No, no, no. Next.
May it please your lordship, my lord. This is my application coming up at my instance, my lord.
Who's appearing for the respondents?
My lord, Mr. Day is appearing. Sir, আপনি আছেন। হ্যাঁ, অপু রাইস মিস্টার।
I am not coming.
Extension.
Extension.
Your lordship can extend the.
Extension of.
Just,
It order first. কবে আসবে ডেট নেই
this is last.
Report was called for from the state.
My lord, report has been filed, my lord. We were supposed to use an exception, my lord. We have prepared an exception.
You're filing it today?
Just,
It's at the motion stage, isn't it?
it is at the motion. It is made returnable as a motion stage matter, my lord. My lord, I have the report with me. My lord, if your lordship so desires, my lord.
This is the exception.
Exception, my lord. My lord, I'll serve a copy on Mr. Day, my lord, during the course of the day.
Filed by the petitioner is taken on record.
original sir
Paragraph, let the matter appear under the heading Group 1 motion on 11 January.
My lord, the interim
Paragraph,
order.
interim order granted earlier is extended till 31st January or until further orders, comma, whichever is earlier.
I'm grateful, my lord. 31st January.
Item 3.
Your lord, I am appearing for the earliest contempt now.
Yes, complied.
My lord, kindly see my lord's last order, my lord. This is, my lord, the issue, my lord, regarding the donation of the land by the petitioner. Since there is a Borgadar and in the some portion.
That in between the land is occupied.
So,
by
my lord, the
Have you taken steps for correction of record of rights?
Yes, my lord.
Is that done? And what about the water body? I missed. Where is the corrected record of rights?
Yes, my lord.
The record of rights?
Record of rights were annexed to the affidavit or to their application.
It was submitted that portion of 2284. 2282 is a water body.
My lord, record is jol means I have scrutinized. Jol means that is called a Namojomi, Khaljomi, and paddy land. Where the agriculture is cropped up. The land is under cultivation and it is cultivated by my client for a long period.
So the Borgadar part is over. There is no
No, no,
Borgadar.
No Borgadar.
Matlab 2284 matlab relates to matlab the cultivable land, that is matlab the Borgadar issue is there. And 2282 matlab inspection report says portion of the land there is a doba. Matlab that is matlab the last.
The report.
Jol means not doba. Jol means
না 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 আরে আমি ওটা জল
Upon
বলিনি,
physical inspection,
আমরা রিপোর্টে কোনখানে সে বলেছিল না ডোবা আছে।
now if the state is not willing to take a donation, why are you insisting? Drop the idea.
No, my lord. My lord, in the Bengal, all the lands except Vastu lands are cultivation lands.
Donation is a give and take.
Yes.
There should be a donor and there should be acceptance of the donation. If the state is not accepting, can it be a unilateral?
These points are discussed in the petition itself. After satisfying my lord passed the order. Now it is a case of contempt application.
Now my lord kindly matlab the writ petition my lords passed an order directing matlab the by allowing the writ petition prior A. Matlab kindly matlab the whether matlab this is willful and deliberate violation is there.
Respondent also, they are actually discriminating the order of the honorable court, other respondents, because respondent who is willing to execute the deed of gift, other respondent who actually signs the DL and LRO, they are disturbing by very serious means, and in annexed it appears that he
That is not the case of the contender.
My lord, may I matlab the matlab kindly come matlab the P1 of the writ petition. Matlab that is representation. Representation matlab he specifically stated. Matlab may I?
Let us see what was prayer A. It has been allowed in terms of prayer A.
Yes, matlab prayer A my lord. Page 14. Yes. But in the contempt petition, page 42.
To complete execution of necessary deed of gift.
Now, my lord, as will decided between the parties in the deed which has been described in annexure P1. Now, my lord, kindly take up my lord, the P1. P1, my lord, he made an application for my lord, his willingness to donate this land.
Yes.
Now, my lord, kindly comes to paragraph 3. Paragraph 3, my lord, middle portion, it is written, if inquiry report proves clear entitle of the land in my favor, then I wish to donate the aforesaid land for the interest of the public. So, my lord, the clear entitlement is not, my lord, yeah. Now we have already, my lord, taken steps. My lord, he already approached for correction of record, which that was also not done at present. So, my lord, the willful and deliberate violation, my respectful submission is not there. So, my lord, in the contempt, my lord, we have, my lord, already taken steps. We have stated our difficulties. This is the, my lord, issue. Now,
actually no difficulty, but you are state of the gazing.
my lord, the,
There is no border.
my lord,
Jol is recorded.
no, my lord, I am not disputing Jol is not a cultivable land. Jol is cultivable land, the fellow land. In respect of the land which is classified as Jol, in that portion, Borgata recording is there. And another plot 2282.
The water body is 2282.
2282 is my lord, that is not my lord, the Borgata there.
Somebody offered the land to give a-
You have said 2284 is occupied by Borgadar.
Yes, and
Today's supplementary affidavit doesn't say so.
supplementary affidavit my lord, shows he filed an application for correction. Supplementary affidavit page 4. To the district magistrate, ADMLR and BLNLR for correction of record of rights.
The request to real on last question to BLO.
मतलब subject correction record of rights in respect of land 2284.
Yes.
Only land is elevated to the ground level, road level. This is to be done for construct any hospital or any project. That is usually done by all of us. Even if person I will elevate the land after ground level, they are trying to construct. Therefore, John we recorded no part to take gift of the land. However, they are only other respondents are only.
You done the necessary correction of records.
Yes, later, just have sent it. There is an important annexure where the.
This is sent by you.
Yes, my.
Where is the corrected record of rights?
My lord, see the letter.
Because it has to be clear title, isn't it?
No, this is I am sorry. As per section 50 of WL Act and rule 21 of the W rules, it is own motion when the on spot inspection the RI says that there is the no Kolkata, it is the duty on own motion to execute the record. It is section 50 of the WL Act and also rule 21 of the rules.
Page 6 says that it is in possession of the petitioner. Page 6 of the supplementary affidavit. Filed today.
मतलब that is the possession of the petitioner through Borgada. That is not here the possession, that is the land always belongs to the Rayot. The Rayot is through Borgada. Now what I am he has filed an application for correction. That correction not been effected till now.
Not only that,
My land.
Yes, so please get the corrected records first. Then only this can be considered.
My lord, give me the letter. Just verify and sign. There is a letter. I am there. Letter of the government authority.
কোনটা কত পেজ দেখাচ্ছে
Yes, this is a letter written by you.
No, written by you, but there is annexure. In for annexure where state authority is asking the BLRO, let me the record. And see, I will do.
কোথায় কোথায় বলুন বলুন কোন জায়গাটা কোনটা এই চিঠিটা আপনার চিঠিটা
This part.
তুমি ইয়ে করো
How does this help you?
This help you that they.
This is a 2022 letter.
They know very well that and you can see the copy to and they but the copy to correct the record of rights.
Please show me the corrected record of rights. This doesn't help you at the moment.
Well, they ask them to check the records.
Here you are authorized to execute the deed of gift. That was there all throughout. But they are not accepting it because there is a Borgadar in one of the lands.
Well, I can show from the Lord Borgada is a clear and like the land.
From where can you show that the land is not in possession of the Borgadar? There is nothing.
If it is my application, it is the report also.
Your application doesn't prove anything,
No,
sir.
it is their report, there no Borgada. It is their report.
Please show me where it is written no Borgadar. It is written it is in your possession. That's all.
No, not one person.
Please show me one sentence that there is no Borgadar.
I know the next page.
Yes, page 6.
I'm showing another.
Page 6.
Huh?
Page 6.
This is their supplement. It is my affidavit in reply to affidavit of the condemner.
My lord, what I am kindly comes to our opposition, my lord, page
Please
32.
show me one line that there is no Borgadar.
I'm showing. Take up my lord, affidavit of behalf of the alleged condemner filed by them.
Yes.
Here, my lord. Page 30. Page 32.
Yes, my lord, I am also my lord the same page 32 regarding 2282, second paragraph.
Allow me to submit.
Mala, that is the water body.
Let him, sir. Page 42.
32 of their affidavit
Yes, page 32.
on behalf of the alleged contempt. Come at page 32. Come to the bottom portion. এই দাগ সংক্রান্ত প্রতিবেদন উক্ত দাগে মোট পরিমাণ 50 শতক রাজনীতির 26 অংশের আরো দেখা যায় জনৈক ভূতান বর্মন পিতা চন্দ্রমোহন বয়স বর্গাদারের কোনো সন্ধান পাওয়া যায় নাই জমি satisfaction report on the part of the appeal authority. Therefore, my lord, the next annexure is 39. Same.
Yes, what further do you want?
Mala, kindly comes to page 32 again.
Yes.
Regarding 2282.
It is
Regarding-
Jol.
That is one portion of the land has been is the water body. Report says.
Recorded as Jol. You have just now said that Jol may be cultivable land also.
No, 2282.
Yes, 2282.
2282 দাগ সংক্রান্ত প্রতিবেদন উপস্থিত ব্যক্তিগণের মন্তব্যে জানিতে পারলে উক্ত দাগে অনিল বর্মনের
শ্রেণী জল
40 শতক জমি হাল রেকর্ডে রয়েছে জমিটি শ্রেণী জল দ্যাট ইজ কাল্টিভেট বর্তমানে
চাষাবাদ করছে।
না আমরা নেক্সট বর্তমানে তিনি জনমজুরের মাধ্যমে জমিটি উক্ত দাগে
Yes.
প্রায় 10 শতক পরিমাণ জমিতে পুকুর রইয়াছে মানে দ্যাট ইজ টোটাল ল্যান্ড ইজ 40 decimals. Out of 40 decimals, 10 decimals has been the water body. And now regarding 2284, regarding 2284, kindly see the next page 33.
Yes.
বর্গাদারের সন্ধান পাওয়া যায়নি এবং উক্ত দাগের সাচানসাচ জমি পূর্বে কয়েক বছর যাবত মৃণাল বর্মন পিতা সাচানসাচ পূর্বে কয়েক বছর চাষ করতেন তারপর উনার ভাই প্রবাল বর্মন 3 বছর ধরে চাষাবাদ উক্ত দাগটি গ্রামীণ রাস্তা হইতে লাগোয়া হইতেছে
So no Borgadar.
now the borgar recording is there formal the correction is required whether if the their case is the borgadar expired long ago nobody is cultivating the riot is cultivating the land so that this is attract the 17 also so the necessary
They will
proceedings
do their what is necessary. They'll take necessary steps. They have taken necessary steps.
no that is
The correction is waiting. What about this Jol part? Borgadar part
No.
is solved. There is no Borgadar. It is evident. What about 2282, the Pukur? Yes. Written, sir. Page 32.
Page 32.
Recorded as Jol and 10 decimals, there is Pukur.
ব্যক্তিগণের জানতে পারলাম যে এই কোনো দর্শনের জন্য হালের পুকুর শ্রেণী জল শ্রেণী রেকর্ডের জল
Read the entire paragraph, please.
বর্তমানে তিনি পান মজুরের মাধ্যমে জমি চাষাবাদ করছেন উক্ত দাগে প্রায় 10 শতক পরিমাণ জমি পুকুর রয়েছে my lord it is recorded as জল and if it is from down level it will elevated to ground level then there are no hospital level if hospital level is not elevated then it is
Pukur is a water body.
Pukur is not recorded pukur
Pukur is not a. Please see the report, sir. Please do not repeat your submission. The last line of the paragraph.
উক্ত দাগে প্রায় উক্ত দাগে প্রায় 10 শতক পরিমাণ জমিতে পুকুর রয়েছে
Yes.
মাঠ ছোট পুকুর
পুকুর আছে মাছ চাষে দেন
মানে 1 শতক মিস মানে 8 কাঠা হবে 9 কাঠা হবে only 9 কাঠা out of 7 decimals
so that cannot be utilized for construction. A water body can be utilized for construction.
Record is jot. Record is not found. Therefore, even the low land, it will be elevated. Land
It is not lowland, sir. It is water body. Content will be dropped. There is no ground. Can you take 2283 and the other two plots?
now others between two plots another person's land is there we cannot use this is a continuous
There
plot
is no another person's land in between.
yes Malad, that is that kindly see the Malad, the sketch map
284 and 282 may be recorded with the tax. Because in 284 there are another concept that there is no access. So they did not 282, 284 other is clear. And only that the land has 10 feet wide road, adjacent road. Very much fit for starting any building for your hospital. In the picture given at the 39, 40.
Kindly consider this case,
There is
ma'am.
285 in the sketch map.
Kindly see this in this case, ma'am. But the
I denied my affidavit. It's not correct.
this is wrong. This is the
You account the actually 40 and we said all different model.
no, that is not differed. The name of the different riots has been the name mentioned.
Adjoining landowner, that is not our purpose.
It is just a
Where is 2285?
in this map, kindly
This map is annexed.
No, yes, it's not reliable. Not reliable. It's all totally wrong. I've said in my affidavit.
2285, the left side. My lord is the showing the supplementary affidavit sketch map.
Yes, yes.
The left side. Left side 2285.
Extreme left is 2284. After that, there is nothing.
This in a Bengali, in the
2285. You say that there is no access.
yes. Kindly see the latest the map.
The one that you've given just now.
Yes. The name of the different riots is there. We have mentioned the name of the persons of the Anil Burman's land. Anil Burman's land and others' land. We cannot go for the other person's land.
My lord, they drawn a picture as per their will. Actual picture is given in page 40 of their application. In my page 26. That delineation is not reliable. That is my
Now, in that even subject to my lord's consideration, in their presence, we shall inspect whether access is there or not. If access is possible, then we shall they will. Otherwise,
your my lord wants that department 285. Concept 285 and 282. That is not under on anything. And the land is very well connected to the road.
Only 2284 is a free land, I find.
2282 also.
2282.
2284 now,
2282, there is a water body, cannot be utilized.
That is the order.
Please do not repeat your submission, it will not help.
My lord, then my lord.
It is stated, the inquiry report says that it is Pukur.
My lord, I have referred the letter. I have asked.
So you cannot insist them to take the Pukur.
My lord, I have asked my letter that you explain what is JOL to the government authorities.
Jol is not necessary. It is Pukur, not Jol.
The client is also saying the physiculture is going on.
And I have just been informed that pisciculture is going on there.
In 2285.
2282, not 25. Not
2282, not pisciculture is going on.
I see.
2285, there is no water body.
My lord, 2282,
No, and out of that, 10 decimals is water body.
So 10 is 2285.
2285, there is no water body. I think we are spending time unnecessarily on this.
2282. My lord, whatever 2282 is some any embargo for action if after taking any hospital purpose, there is
A gift involves acceptance. If they do not want to accept, the court cannot insist on acceptance of a gift. Right?
They have said that there are three kind of barrier. One is some part of it.
Will you come back with a fresh affidavit saying that you cannot accept?
My lord, I shall.
Yes.
Stating our difficulties, my lord,
Yes.
we shall explain
your
our
difficulties.
difficulties.
Yes, the
The-
court cannot insist
for
on
that reason.
acceptance. It's a gift. Please come back with a detailed affidavit
My
stating the reasons for your inability to accept the gift.
My lord, I in the counter application, other respondents were made part, but since the order was passed only on joint secretary number, no notice was said. But in this one, can they be ordered person?
Not necessary. Not necessary. The facts are before the court. I don't think we should spend further time on this. Learned counsel for the alleged contemner submits that the state is not in a position to accept the land intended to be donated by the applicant petitioner on for several reasons. Stop. Learned counsel seeks to submit a comprehensive affidavit stating such reasons. Paragraph, let the matter appear. Please serve an advance copy.
My lord.
Let the matter appear under the same heading on. You'll come back after vacation? Yes, yes. Oh, তার আগে শুরুতে means supplementary affidavit submitted on behalf of the applicant petitioner is taken on record. Yes?
7 days prior to the filing.
Yes, yes.
14 December. Sufficient? You want to come back after vacation?
And only I want the 7 days prior of service of them.
Serve an advance copy so that he can deal with
So,
it.
my lord, in that event, my lord, fixed after vacation, I shall give a advance copy.
Very well, 5th January. 5th January 2024.
না না এনকোয়ারি করে আবার ফাইনাল এনকোয়ারি করব না
Next. জলপাইগুড়ি পরের টাই? I'll take up the Jalpaiguri Circuit Bench matter, a contempt application.
Item 1, Jalpaiguri Circuit Bench.
Yes, contemner. Fine. Order is at page.
My lordship,
The order under contempt,
27.
page 27. Mr. Dey, you are appearing?
Yes.
Yes, what is your allegation?
My lordship,
আপনি বাংলায় বলতে চান?
my
You want to submit in Bengali? Yes, do that.
My lordship, লাস্ট 11 আগস্ট 2023 একটা অর্ডার হয়েছিল। সেই অর্ডারে স্টেট রেসপন্ডেন্ট সাবমিট করছিল যে আমার এই কন্টেম্প
Order
অ্যারাইজিং অর্ডারটা কমপ্লাই হবে, কিন্তু তার কিছুই হয়নি। মাই লর্ডশিপ যে কনস্ট্রাকশনটা করেছিল সেই প্লটে ডিক্রিট পজেশন ইভেন যেটার উপরে হাইকোর্ট এই কোর্টের অর্ডার ছিল, সেই কনস্ট্রাকশন আরো এক্সটেনশন করেছে। গত পরশুদিন
December 2011 এর জাজমেন্টটা কোথায় আছে?
স্যার 11th স্যার
December 2011 এ একটা জাজমেন্ট হয়েছিল।
ইয়েস মাই লর্ডশিপ,
Where is the judgment?
মাই লর্ডশিপ
Next করেছেন এর সাথে জাজমেন্টটা?
নো মাই লর্ডশিপ, ইয়েস মাই লর্ডশিপ, ইয়েস মাই লর্ডশিপ।
টাইটেল সুট 112 of 2010 একটা
lordship.
জাজমেন্ট হয়েছিল। ওই জাজমেন্টটা কমপ্লাই করার কথা বলা হয়েছিল এই
Yes,
অর্ডারে,
my
তাই তো?
lordship. The judgment is at page
Page?
number 17.
17.
1 second.
This is violation of a trial court judgment.
I've seen my lord.
Will contempt lie before this court?
My lord, and the contempt is not in the form. But in the High Court rule.
No, but primarily it's violation of a trial court judgment.
Yes, ma'am.
Of course, this court has also directed compliance of the judgment.
As he is in person, my lord.
The judgment was not to disturb the possession of the plaintiffs, but that has not been done. Will you take instructions?
Yes.
Because the lady has been suffering for quite some time.
He is in person, my lord, for that is. Otherwise, my lord, I took the point that.
No, 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 let us not do that. Yes, let us go into merits.
He is in
Yes.
person, my lord.
Yes,
So,
let
my
us
lord,
go
I
into
cannot-
merits.
I
So-
must.
Yes,
Report to the proud of it.
let him come back with a report.
My
Yes.
lordship, next day.
Because the lady has been suffering for quite some time.
Yes, my lord.
In Jalpaiguri court also, she has several matters.
I must. That's my-
My lordship,
This is operation of the weaker section by the powerful.
Yes, my lord, I must consider.
Yes, when can you come back again? কবে ফেরত আসতে পারবেন আপনি?
my lordship, after 8 December.
When can you come back with the report?
In December, your lordship can reach. That is the 15th or that is the.
Will you come back on 13th? 13th December?
My lordship, I can give some documents which is supported this contempt petition by supplementary affidavit. My lordship, an order of supplementary affidavit.
Yes, yes, I'll do that. On the same day, please serve an advance copy to Mr. Dey. Mr. Dey is always in this court. Yes, you can find him here. On prayer of the applicant petitioner, comma, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, learned counsel for the alleged contemner seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 13th December.
And a report in the form of evidence.
Please take instructions as to what is happening. 13th December.
My lordship, 13 December পর্যন্ত খুব অত্যাচার করছে my lordship. Some order for
My lord, I must.
interim relief.
My client.
Mr. Dey has taken charge. Don't worry, he'll look into it. Okay.
এবার এই করো বাড়ি যাও আমি বলে দেবো আজকে
Regular bench matter, item 4.
My lord, I am for the petitioner. My lord, I must be candid. My lord, I must be candid to this, my lord, that there was a,
Application.
yes, review application, there was a direction filing affidavit. I have contacted my client, but my client is not sure as to whether he has received the awarded money or not. So what I will be praying before your lordship, my lord, if your lordship kindly direct the state to produce the record, because I tell your lordship why. Because award is required to be passed in this case, my lord, under section 7. And notice is required to be served under section 7. But I do not find any such notice that has ever been served. On the contrary, affidavit was used, affidavit in opposition, whereby they admitted that 80% payment was made in 2 phases. On the basis of their admission, my lord, your lordship was kind enough to dispose of the matter. Now, review application has been filed saying that nowhere it has been said that the affidavit in opposition wrongly filed or there was a wrong misstatement.
activity in opposition. There is also my lord final 2 item is there, my lord. But that was my lord overlooked by us.
Why don't you come with the affidavit in opposition? Are you
But what I will be praying before your lordship, my lord, I don't want the state should suffer, and I don't want to take advantage of my order of your lordship. But what I am praying,
I bring all the
records.
additional records.
My lord,
and
that will
my lord
suffice.
will and show my.
Yes,
to my,
yes.
learned friend, my lord.
Because I
Your
don't.
lordship can give one another.
But I don't want that my client will be, my lord, be benefited by this order, my lord.
My lord, I can't. When the original record had come, I must show my lord.
Kindly give
I
some
didn't
time,
want
my lord.
to
Only thing, my lord, if I satisfy, I will concede to your lordship, my lord, that my reply application should be dismissed.
Or learned counsels for the parties, review order. The state respondents, I'll give a direction for
Production of records. Yes, yes. But that is required.
Well, your lordship, yes,
Yes, I'll give a direction,
part my lord.
or I'll record your submission.
Yes, my lord.
The state respondents are directed to
Yes.
produce all original records pertaining to the acquisition in question
Madam.
on the adjourned date.
Madam.
In the meantime, my lord, I come with the brief and my lord, all the records were.
Yes, yes, madam.
Please sit to
If I,
file
yes,
the
my lord, if I
case.
find, my lord, immediately I will be praying before lordship, my lord, to dismiss my writ application.
When will you come back after vacation?
After this one?
After vacation? 11th January?
Madam.
Let the matter appear under the same heading on 11th January 2024.
And next, both the matters. Right?
4 and 5.
4 and 5.
4 and 5, same on, 5 is same on.
4 and 5. It's alada order.
4, 5 is, it's with 5, it's together.
Yes, yes.
Review the order. It's appearing together.
Madam.
Yes, next.
Item 6.
For the petitioner lordship. In this matter, lordship, I want to use an exception. I prepared, but due to my some personal difficulty, no, yes, status. So I'll just use an exception. Kindly give me any short date, your lordship. I'll file it and come back.
Learned counsel for the petitioner seeks to use an exception to the report in the form of affidavit submitted on behalf of the state respondents. Paragraph, let the matter appear under the same heading on 14 December.
Item 7.
My lord, I'm for the Birbhum Jila Parishad.
For the,
Birbhum Jila Parishad.
Your lordship
They were-
directed to submit a report.
yes, where is the report?
We have not,
He is not present, therefore today is fixed for submitting.
we have
You're
not
even
received,
present on every date. Yes,
my lord, we have not received yet some of documents. We need some time. Give 3 weeks time.
How
We
many
need
days?
3 weeks
appear
time.
on every date. On the earlier date, you did not appear at all.
Yes.
Yes, otherwise it will be heard in your absence.
In spite of none of
Learned
these,
counsel for the Jila Parishad seeks extension of time to submit the report as sought. Submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 18 December. Please serve an advance copy.
Get full.
Item 8.
in spite of undertaking before the court, he has completed the
Yes,
undertaking given by the court. They stop the construction of road. In spite of that, they have completed the.
let us,
Therefore, they have not submitted a report before your lordship.
let us. Yes, next matter.
Item 8.
Your lordship, I'm for the petitioner in this matter. There was a direction upon me to file the reply, your lordship, to the affidavit. That is prepared, your lordship. Today only I affirm it. I'll give a,
Sometime.
yes, I need some time because I have already prepared that, but the affirmation will be done today only.
Learned counsel for the petitioner seeks to use an exception to the report in the form of affidavit submitted on behalf of the respondents. Paragraph, let the matter appear under the same heading on, when did I fix the earlier matter?
14th, your lordship.
Let this also appear.
Yes, sir.
14 this.
Reply of lordship.
Next.
Data problem হলো 14
9.
Item 9 appears for the petitioner lordship. Lordship, we have served them affidavit of service on record. Lordship, on the last occasion, again gave them a chance. My advocate record has called and informed. Seems like the state is not interested. Lordship, I am seeking a parity of an order, Lordship. My family land was taken over in the construction of Bokreshwar plant.
Give him.
Lordship.
That is, may I request Mr. Dey to appear? You are served and over. Mr. Dey, may I request you to appear in this matter?
Lordship, there is an
Please serve a copy of the writ
I
petition.
shall. Only thing, Lordship, only thing. Lordship, there is an order of this court. Same, my cousin, same situation, everything is similar.
What's the matter about?
Lordship, may I? Lordship, I had lost land. I am a land loser, Lordship. My grandfather was a land loser in the construction of Bokreshwar plant. Thereafter, Lordship, by a notification, we were told that we would be given jobs. Anyone who is nominated by the family would be given a job. I am the granddaughter of the person who lost the land. Lordship, my name was proposed. Hearing was conducted. The fate of the hearing was not told to us. We waited. We gave an RTI, and we are informed that my name has not been included. We have learned that our name has not been included because the state contended that there was a further notification by which this previous notification was modified. Lordship, this honorable court, by an order dated in 2015, had considered such a situation. Coincidentally, Lordship, the petitioner was my uncle, my parallel branch of the family. Was considered, the court had held that the subsequent notification is non-est and the state is duty bound to take into consideration the nominee of the family of the land loser. This order was carried out in appeal by the West Bengal state government, Lordship. The appeal court has also upheld the order of the single bench. Today, Lordship, I have this order in hand. All I am saying, similarly situated, exactly the same situation, Lordship. If my learned senior is kind enough, Lordship may pass a similar order. I have the order, Lordship.
Today, I believe needs to go through the records because you're asking for an employment.
Then I shall serve a copy of the writ petition along with the order to Mr. At the shortest.
Please take necessary instructions. Yes, ma'am. None appears for the state respondents despite service, regularized quorum, copies of the directory. Learned counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter. Please hand over a copy of the judgment on the next.
I shall do both. I shall do that.
By the court on the next date.
Okay, Lordship. I can hand over right now if the Lordship wants. Okay, Lordship.
Let the matter appear under the same heading on 8th December.
Lordship.
Mr. Dev, 8th December.
Lordship. I am grateful. Petitioner a copy of judgment.
10. My lord, I beg to appear for the petitioner led by Mr. Patrapati Moy.
My lord, in this matter, in lordship direction, lordship, I want to file my report, my lord.
A copy.
Yes.
Court.
My lord, in court today, my lord.
My lord, if exception is required to be filed, my lord, I shall file. My lord, kindly grant liberty to file. My lord, already Mr. Day has filed one report, my lord. I have not filed yet, my lord, any exception. If required, my lord, I shall file.
Report in the form of affidavit submitted on behalf of the National Highways Authority is taken on record. Paragraph on prayer of the petitioners, liberty is granted to use exceptions to both the reports if required. Paragraph, let the matter appear after vacation.
My lord, after vacation, my lord, prior to vacation, if possible, my lord, subject to my lord's convenience.
19.
19. Grateful.
19. December.
11. Item 11.
That supplemented affidavit could not make ready.
Could not be made ready. Who is appearing with the respondents?
Mr. HON'BLE Roy appearing for the municipality.
Time nahi to. No time nahi to. Hai bola. Khule bola. So I am saved.
On the previous day also you sought extension.
Yes. Due to the intervention of holidays, everything is out of mind.
So it's very difficult to come back. Learned counsel for the petitioners seeks further extension of time to use the supplementary affidavit as sought. You are for the municipality.
Yes, Mr. Rice for the municipality.
Learned counsel appearing for the municipality also seeks accommodation. Paragraph after vacation.
I have no problem.
Yes. You are the petitioner. If you have,
but I have no problem. No. If I am enjoying an interim order, then there will be no problem.
8th January.
Yes.
Let the matter appear under the same heading on 8th January. Please serve an advance copy.
I'm sorry, my lord. Item number 10, I could not be there.
Item 12.
Item number 10, my lord. My junior was there, prayed for, Only 8.
Then an order has been
In
passed.
case of 18 December, if it can be extended, because in a Honorable High Court, I will not pray for time every time before this Honorable Court. So I will inform the other side if your Lordship gives some time, because I don't want to be in such an embarrassed condition before this Honorable.
I do not remember. You are appearing in 18. So for the petitioner.
I am for the respondent Jela Parishad Marat. I have to come with a clarification regarding report.
Yes, yes.
Monica and
Petitioner was already objecting to the extension, so
And I don't want to be.
Pati Rai is there, my lord.
you want to come back after vacation?
After if petitioner will also be benefited if I come with a specific report. Numerous times I don't want to pray for
9th
time.
January.
My lord.
Rajiv, 9th January.
I inform her.
But you have to inform the petitioner.
9 January. Our presence may be recorded.
Item.
Item 12, Lordship. Lordship, Langan advocate is not present today, Lordship. I am praying for not to, Lordship.
12.
Yes, Lordship.
You are the petitioner?
Yes, Lordship.
9 January.
Actually, I am for the state.
Item 7.
Come back after vacation? On prayer of the petitioner, the matter is
Item seven.
adjourned. Paragraph, let the matter appear under the same heading on. Yes?
7. It will be, I am sorry, not 10. 7, but just I mentioned. Item number 7.
My lord,
You mentioned,
No, I am sorry, my lord. I'm 7. It will be 7.
I'm sorry, I cannot change dates like this. Other side is not there. Rajiv, what are the
I will inform them.
1912.
Picture is created
ওইটা রেখে দিন।
on the side. Do not
Bye,
bother.
As you lord.
Item 12, your
Yes, Lordship. Item 12.
on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 11 January
Yes, Lordship.
2024.
13.
My lord, I beg to appear of the petition. This matter, my lord, your lordship will recollect that I completed my
Responding?
respondent, Mr. Talukdar, is my lord.
Coming.
He is on legs, like coming, my lord. But my lord, shall recollect, my lord, this is the matter, my lord. A medical institute was going to be, my lord, construction of going to be taken place for, my lord, a medical institute, and that is a charitable institute. My lord,
Is appealing for the state? State?
my lord, in this matter, my lord, an allotment was given to the petitioner for construction of building for the medical institution. My lord. Now, my lord, in the lease deed, there was a covenant that within a specified period, my lord, the construction has to be commenced, and my lord, the construction has to be completed. Now, my lord, the petitioner, my lord, faced several predicaments. I have stated in the writ petition, and at the time of my lord argument, I have also placed before lordship, my lord, that due to, my lord, such predicaments, my lord, the mutation and the sanction plan could not be obtained in time. My lord, after obtaining the sanction plan, when the petitioner was going to construct the, my lord, commence the construction work, now all of a sudden the KMDA, my lord, issued one demand notice stating, oh my, Mr. Talukdar has come.
I think submission of both the, even the KMDA was completed because the judge.
No, not yet completed, my lord, just
You've referred to certain judgments.
verge of completion.
KMDA has referred to certain judgments. I have taken
Only-
it in the note.
In respect of one case, perhaps one case, Damodar's case was, I cannot remember.
Yes, Damodar, you have referred.
Only Damodar was
Referred
placed.
Radha Krishna Agarwal.
Berili, Radhakrishna and Berili.
Yes, you've referred that. Then you've referred to Berili. Yes,
Yes.
they're all on record. And
So
you've made a
little-
lengthy submission. I have it recorded.
But
You didn't complete.
I hadn't
You've also
concluded
recorded,
my
This is Damodar, yes.
some submissions on that. So if petitioner again starts, then I have to.
No, he was just.
No, in your absence, I was just.
You were not there. He was.
I see. I'm
Sorry, Mr.
No.
I never.
Oh, St. Mary's Education Society, you have cited several judgments.
I never tried to take your valuable rights.
On the last occasion, I have placed the facts stated. And Milord, some of my points, Milord, may I recapitulate, Milord. Based on the facts, Milord, this writ petition has been filed suppressing a very material fact. It was contended in the writ petition that no opportunity was given to the petition. Although facts remain that there was a show cause notice and the petitioner had replied to that.
That is also recorded, yes.
So suppressing that fact, the writ petition has been filed and it has been categorically denied that fact. So that suppression is one of my ground, Milord, that on the ground of which the writ petition is liable to be dismissed. And another point I took, Milord, the point of delay. The cancellation order was issued in the year 2016. But this writ petition has been affirmed in May 2022. And there has been no explanation as to the delay in filing the writ petition. And the another point, Milord, the contractual terms. On the contractual terms, Milord, I place the
You say it is a concluded contract.
concluded contract. So parties are, it's a bilateral contract. The parties are bound by the terms of the contract. On that point, Milord, I placed the case of Radhakrishna Agarwal, and which was relied on subsequently in Bareilly development. And third one, perhaps I have relied on the judgment delivered by your lordship in Damodar Prasad Agarwal, which was affirmed by the division bench as also by the Supreme Court. SLP was dismissed, thereby affirming your lordship's order. So lordship took into consideration of all these cases, Radhakrishna Agarwal, Bareilly Development, Bandha Development Authority, all these cases, Milord, I cited, lordship took into consideration of all this. So after that, Milord, after this judgment, there is no scope remains. Because as per the terms of the contract, there has been a breach. It is an admitted fact. Which, Milord, warrants cancellation of the allotment vis-a-vis the lease itself. The authority exercised that power under the contract. Before exercising, when prayer was made for extension of interim order, as per our policy, we offered the petitioner an opportunity. So, as per the policy, if you pay these penal charges, you may be allowed to continue. Though the petitioner, Milord, agreed to, lordship, that if your lordship kindly takes up my affidavit in reply, affidavit in opposition once. Lordship kindly turns to page 18 of my affidavit in opposition.
Yes.
Before that, Milord,
all these have been placed earlier.
Yes, yes,
Yes, these are all placed earlier.
And this is repetition.
This is repetition.
These are all placed earlier, Mr. Kalyan.
Yes. This page 18 is the prayer. No, I'm just.
আচ্ছা তাহলে তো আমাকে প্রথম থেকে বলতে হবে, আমি তো তোমার আগে শেষ করি।
Then your lordship will find
সব বলতে হবে।
page 18. May I read this letter? The above plot was given possession on to us on so and so date. We were to start construction on such and such date. We have taken all necessary steps, including so and so. File is now in municipal building committee. The final sanction is expected shortly. Since the file is presently pending with the KMC, we would request you to grant an extension of 6 months. Then, my lord, the show cause notice which has been suppressed by the petitioner. Because in reply, why I am showing this? In reply to the show cause notice, my lord, next page, lord, if your lordship turns to page 20, the last paragraph, my lord.
Yes, you have referred to all this earlier.
Yes, I referred. I'm sorry, my lord. Then we put condition the next page. So, my lord, on the contractual terms, my lord, on the point of contractual terms, my lord, that these decisions, my lord, I have already cited.
Right.
My lord, next point, my lord, on the point of delay, I have not cited any decision. I have.
Refer, I'll find out, yes. Delay, because delay, you have made your submission.
Digombor's case, I have. Two or three decision I will set.
Now, this is St. Mary's Education Society.
No, that is not. Digombor was not cited. Kindly. No, this is reported in 1995 4 SCC, page 683. 683. So she kindly take up two paragraphs, paragraph 14.
Sorry, sir.
14, 19, 23, 25 and 26.
14, 19.
14, 19, 23, 25 and 26. May I read this? How a person who alleges against the state of deprivation of his legal right can get relief of compensation from the state by invoking writ jurisdiction of the High Court under Article 226 of the Constitution, even though he is guilty of laches or undue delay, is difficult to comprehend. When it is well settled by the decision of this court that no person, be he is a citizen or otherwise, is entitled to obtain the equitable relief under Article 226 of the Constitution if his conduct is blameworthy because of laches, undue delay, acquiescence, waiver, and the like. Moreover, how a citizen claiming discretionary relief under Article 226 of the Constitution against a state could be relieved of his obligation to establish his unblameworthy conduct for getting such relief, where the state against which relief is sought is a welfare state, is also difficult to comprehend. Where the relief sought under Article 226 of the Constitution by a person against the welfare state is founded on its alleged illegal or wrongful executive action, the need to explain laches or undue delay on his part to obtain such relief should, if explained, should, if anything, be more stringent than in other cases, for the reasons that the state, due to laches or undue delay on the part of the person seeking relief, may not be able to show that the executive action complained of was legal or correct for want of records pertaining to the action, or for the officers who were responsible for such action not being available later on. Further, where granting of relief is claimed against the state on the alleged unwarranted executive action is bound to result in loss to the public exchequer of the state or in damage to other public interest. The High Court, before granting such relief, is required to satisfy itself the delay or laches on the part of a citizen or any other person in approaching for relief under Article 226 of the Constitution on the alleged violation of his legal right was wholly justified in the facts and circumstances, instead of ignoring the same or leniently considering it. Thus, in our view, persons seeking relief against the state under Article 226 of the Constitution, be they citizens or otherwise, cannot get discretionary relief obtainable thereunder unless they fully satisfy the High Court that the facts and circumstances of the case clearly justified the laches or undue delay on their part in approaching the court for grant of such discretionary relief. Therefore, where a High Court grants relief to a citizen or any other person under Article 226 of the Constitution against any person, including the state, without considering his blameworthy conduct, such as laches or undue delay, acquiescence or waiver, the relief so granted becomes unsustainable, even if the relief was granted in respect of the alleged deprivation of his legal right by the state. Then you'll also kindly turn to paragraph 19. Power of the High Court, I am reading paragraph 19. Power of the High Court to be exercised under Article 226 of the Constitution. If it is discretionary, its exercise must be judicious and reasonable, admits of no controversy. It is for that reason a person's entitlement for relief from a High Court under Article 226 of the Constitution, be it against the state or anybody else, even if it is founded on the allegation of infringement of his legal right, has to necessarily depend upon unblameworthy conduct of the person seeking relief. And the court refuses to grant the discretionary relief to such person in exercise of such power when he approaches it with unclean hands and blameworthy conduct. Same principle. This I am emphasizing on. He has approached this court with unclean hands. He has suppressed the material fact, not only the delay, it is connected with his conduct also. And then three paragraphs are on the same Miller, 25 and 26. I am not traveling, Your Lordship. This is the same thing repeated in this paragraph. My Lord, have I cited the case of Banda Development Authority? Earlier, this is the difficulty in piecemeal argument. I think not. Barely I have cited. Banda.
Punjab State, this is petitioners.
Banda I have not been, because on the point of delay I have not.
No, I do not find
No,
it for the present.
I'm citing this. 2011, volume 5, SCC 394.
Paragraphs?
Paragraph 15, 16, 17 and 19.
এখানে কিছু ফাইল সাইট করেছে
I am reading from paragraph 15. The above extracted portion of the plain unmistakably show that the respondent had no complaint against the acquisition of land or taking of possession by the state government and delivery thereof to BDA. And the only prayer made by him was that the defendant be directed to undertake fresh acquisition proceeding after subdividing plot number so that he may get his share of compensation. He filed the writ petition questioning the acquisition proceeding after almost 9 years of publication of declaration issued under section 6(1) and about 6 years of the pronouncement of award by the special land acquisition officer. During his so-and-so, these are not material, my lord. I skip to paragraph 60. In our view, even if the objection of delay and laches had not been raised in the affidavit filed on behalf of the BDA and the state government, the High Court was duty bound to take cognizance of the long time gap of 9 years between the issue of declaration under section 6(1) and filing of the writ petition and declined relief to respondent number 1 on the ground that he was guilty of laches because the acquired land had been utilized for implementing the residential scheme and third party rights had been created. The unexplained delay of about 6 years between the passing of award and filing of the writ petition was also sufficient for refusing to entertain the prayer made in the writ petition. Although the subject matter was the acquisition, here is the subject matter is different. But here, the question of delay, the court is also duty bound to take cognizance of that. Here also, my lord, 16 to 20. Cancellation order was passed in 2016 and this writ petition has been filed in May 2022 and no explanation has been given. And two more paragraphs of this judgment, my lord, paragraph 17 and 19. It is true that no limitation has been prescribed for filing a writ petition under Article 226 of the Constitution, but one of the several rules of self-imposed restraint evolved by the superior courts is that High Court will not entertain petitions after long lapse of time because that may adversely affect the settled and crystallized rights of the parties. If the writ petition is filed beyond the period of limitation prescribed for filing a civil suit for similar cause, the High Court will treat the delay unreasonable and decline to entertain the grievance of the petition on merit. Then, the concluding paragraph 19. In matters involving challenge to the acquisition of land for public purpose, this court has consistently held that the delay in filing the writ petition should be viewed seriously and the relief denied to the petitioner if he fails to offer plausible explanation for the delay. The court has also held that the delay of even few years would be fatal to the cause of the petitioner if the acquired land has been partly or wholly utilized. So, although the subject matter of this case, my lord, is a land acquisition, here it is not, but the conduct and the duty of the court, my lord, to take cognizance of the delay and laches. One more. Another judgment on this point. This is reported in 2007, volume 9, SCC, page 278, paragraph 16, the only paragraph.
2007.
9. SCC 278.
Paragraph 16.
16. Only paragraph 16.
Yes.
There is I will read from paragraph 16. There is another aspect of the matter which cannot be lost sight of. The respondent herein filed a writ petition after 17 years. They did not hesitate their grievance for a long time. They, as noted herein, did not claim parity with the 17 workmen at the earliest possible opportunity. They did not implead themselves as parties even in reference made by the state before the industrial tribunal. It is not their case that after 1982, and those employees who were employed or who were recruited after the cut-off date have been granted the said scale of pay. After such a long time, therefore, the writ petitions could not have been entertained even if they are similarly situated. It is right that the discretionary jurisdiction may not be exercised in favor of those who approach the court after a long time. Delay and laches are relevant factors for exercise of equitable jurisdiction. Here, this paragraph is also relevant, my lord. This writ petitioner, although without the leave of the court, has filed a supplementary affidavit at the stage of hearing. Here, he is citing, though no whisper made in the writ petition about discrimination, in the supplementary affidavit, he wanted to cite some instances showing discrimination, that in the case of A, B, C, D, you have allowed, but in my case, you have not. In my respective submission, my lord, by way of supplementary affidavit, my lord knows the Brahmados case. Then in supplementary affidavit, by way of affidavit or by way of a miscellaneous application, you cannot improve your case. You have to make out a case, a substantive case. And more so, my lord, this paragraph 16, he is filing this writ petition almost after 6 years. And even this supplementary affidavit he is filing, my lord, long after, at the stage of hearing, my lord, is citing the other's case. It's a bilateral contract. The parties are bound by the terms of the contract. So other instances where the authority has allowed or not, this is immaterial. Only one more, my lord, I shall not multiply more. Only one more decision I shall decide. Well, this is on this point, the last judgment, my lord. It is reported in 2012, volume 1, SCC, page 66. Volume 1, SCC, page 66. Paragraph 9 and 13. The High Court negative I'm reading paragraph 9. The High Court negative the appellant's plea that in view of Standing Order 28, the respondents were obliged to return the acquired land by observing that the object of utilizing the acquired land cannot remain static for all times, and the same can be used for other purposes. The High Court also observed that once acquired land vested in the state, the same cannot be returned to the owner. That's not material. 13. And this is not material. I'm sorry. This is 13 is to some extent Miller relevant, but 9 is not. It's altogether on different. I'm not citing that.
13 is not in delay.
13 it has some relevance, Miller. Miller, on the point of delay and on contract, Miller, I have placed my submission. Miller, on suppression of material facts, Miller, today I have not brought two judgments I wanted to cite, Miller. And my lord knows the suppression goes to the root. Even if your lordship doesn't permit me to argue on another day, even lordship knows I leave it to your lordship. Only one judgment, so it is not. There are several judgments on suppression of material facts, Millard. If your lordship allows me, I can come. I have not brought that file today. This is of coordinate bench. Here, paragraph 8, lordship will find. This is তোমায় একটা copy দিয়ে দেবো, এটা মৌসুমী হচ্ছে যে only the paragraph 8 last line. Lordship was pleased to take cognizance of that the suppression goes to the root. It goes without saying. And on the ground of which alone the writ petition is liable to be dismissed. And there is no explanation even thereafter. In reply also, the petitioner did not explain that why it was suppressed. But on the contrary, my lord, lordship will find from the reply that the petitioner wanted to justify his misdeeds. The petitioner did not admit that, yes, it was inadvertently that missed. No. On the contrary, he wanted to justify his misdeeds. So on the firstly, my lord, that on the ground of suppression alone, this petition is not entertainable. Because the petitioner did not approach this honorable court with clean hands. He has suppressed to make out a case as if he was not given, and it was argued. My learned friend vehemently argued that no opportunity was given. When I showed one order, if you lordship kindly, lordship has recorded that. If you lordship kindly sees 16 November 2002 order, my lord recorded that.
16th November?
16 November 2022. 2022.
22.
Yes.
Yes.
Lordship kindly reads that order. The primary grievance of the petitioner is that the lease of the petitioner was cancelled by KMD without granting them an opportunity of hearing and without issuance of notice of show cause. So it was done deliberately. Even it was argued before this court. When I showed this, the next paragraph, then Lordship was pleased to grant me liberty to come with a report. And in my report, I have disclosed the show cause notice to which the petitioner had also given reply. Because in the reply, he has given undertaking. That is why he did not want to disclose it. The reason for withholding that was that? Because in the reply, he has undertook to pay. And based on his undertaking, the authority agreed to extend the time on certain conditions. He did not comply with it. Set tight for more than 6 years. And then come up before this court, making out a case as if he was not given any opportunity. So on the ground of which alone this writ petition is not entertained. Then question comes, my lord, delay. That whether after so many years, because my lord knows that these allotments are given for a specific purpose. There are many in the queue. The petitioner's allotment was cancelled long back in 2016. The land was resumed. The money was sought to be refunded thrice on 3 occasions. Lordship will find from my affidavit in opposition that on 3 occasions, my lord, we have tried to refund. We have sent. He refused. He did not accept it. Lordship, all those documents I have annexed with my writ petitions. Lordship will find I have placed on the earlier occasion, my lord. 48 onwards,
46 is the.
46 onwards.
Yes.
On 3 occasions, we have tried to refund the money. Because his prayer, even after cancellation, his prayer was considered by the authority and refused. And the money was sought to be refunded. So on these grounds, my lord, and another point, my lord, though the writ petition does not say so, but this the petitioner filed an application. A CAN application was filed, challenging the policy. Since we referred to the policy, the demand was made in terms of the policy, the calculation. Plus, you will find his application, that is, can. I think can 1. Huh? Yes, can 1. Here he has questioned the policy. Although no such prayer contains the writ petition doesn't contain any such challenge, any such prayer or grounds or pleadings. But by way of a mispetition, he is trying to question the policy. On that point, my lord, 2 judgments are required to be cited, whether the authority in such a situation yes. Well, only 2 decisions I have decided. Because it is although, my lord, it is not entertainable, even then, my lord, when when an application has been made in connection with the writ petition, I must deal with that point also. Whether the authority was empowered to adopt such a policy. This is, my lord, reported in 2006, volume 10, page 337. Page 337. 337. Huh? Para 20. No, sorry.
Paragraph 20.
19. Just a minute, so kindly. May I for a moment take back that one? I have only one copy of the judgment. এখানে দেখো তো এখানে 2019 ভলিউম 9 আছে নাকি 2019 ভলিউম 9 I'm sorry, Milord. I missed that. Oh, two copy,
They are two same judgments.
same judgment. That is why I'm two copies. পাবে না ছেড়ে দাও। প্যারাগ্রাফগুলো লিখে রেখেছিলাম। Lordship, this is paragraph 11. This paragraph 11, page 341. While exercising the power of judicial review of administrative action, the court is not the appellate authority, and the Constitution does not permit the court to direct or advise the executive in the matter of policy or to sermonize qua any matter which under the Constitution lies within the sphere of legislature or the executive, provided these authorities do not transgress their constitutional limits or statutory powers. The scope of judicial inquiry is confined to the question whether the decision taken by the government is against any statutory provisions or is violative of the fundamental rights of the citizen or is opposed to the provision of the Constitution. Thus, the position is that even if the decision taken by the government does not appear to be agreeable to the court, it cannot interfere. The correctness of the reasons which prompted the government in decision making taking one course of action instead of another is not a matter of concern in judicial review, and the court is not the appropriate forum for such investigation. The policy decision, this is, I'm emphasizing on this 7. The policy decision must be left to the government as it alone can decide which policy should be adopted after considering all the points from different angles. In the matter of policy decisions or exercise of discretion by the government, so long as the infringement of fundamental rights is not shown, the courts will have no occasion to interfere, and the court will not and should not substitute its own judgment for the judgment of the executive in such matters. In assessing the propriety of a decision of the government, the court cannot interfere even if a second view is possible from that of the government. Well, the next on this point of policy, the now go. তুমি তো অনেক দেখিয়েছো। Paragraph 28, 32 and 33. Since he has taken that, I would not have argued this point at all, because this is not the subject matter of this.
Paragraphs?
Paragraph 28. Oh, this is reported in 2022, volume 2, SCC 1, page 1. First, my lord, paragraph 28. The issue with regard to, I am reading paragraph 28. The issue with regard to legitimate expectation has been recently considered by a bench of this court, to which one of us, L. Nageshwara Rao, was a member. After considering various authorities on the issue, in Kerala State Breweries Corporation Limited, it was observed thus, quoted paragraph 20, the decision maker's freedom to change the policy in public interest cannot be fettered by applying the principle of substantive legitimate expectation, so long as the government does not act in an arbitrary or in an unreasonable manner. The change in policy does not call for interference by judicial review on the ground of a legitimate expectation of an individual or a group of individuals being defeated. Then, my lord, paragraph 32 and 33.
32 and?
32 and 33. This is the main paragraph, my lord. Paragraph 28. Then paragraph 32. It's a lengthy paragraph, my lord. I place the first part of paragraph 32. There is in paragraph 32, several relevant portion of several judgments have been quoted. Yes. I'm not troubling your lordship reading all this. আমি পরে ট্রাবল দিচ্ছি না। এটা একদম দুনিয়ার বিষয়। Lordship, kindly skip to paragraph 33. I am not reading 32. 33 have cited so many relevant portions from so many judgments delivered by the Supreme Court.
33?
33.
Yes.
It could thus be seen that while exercising power of judicial review, the court is not concerned with the ultimate decision, but the decision-making process. The limited areas in which the court can inquire as to whether a decision-making authority has exceeded its power, committed an error of law, or committed breach of principles of natural justice. It can examine as to whether an authority has reached a decision which no reasonable tribunal would have reached or has abused its power. It is not for the court to determine whether a particular policy or a particular decision taken in the fulfillment of that policy is fair. The court will examine as to whether the decision of an authority is vitiated by illegality, irrationality, or procedural impropriety. While examining the question of irrationality, the court will be guided by the principle of Wednesbury. While applying the Wednesbury principle, the court will examine as to whether the decision of an authority is such that no authority properly directing itself on the relevant law and acting reasonably could have reached it. why I have cited, my lord, if your lordship takes up his CAN application, he has made two statements, paragraph 6 and 7, about this judicial review. 6 to 10, yes, I'm not reading this.
Yes.
Up to 10, yes. So, my lord, this for that, my lord, although the court cannot take cognizance of this, because it is nothing is pleaded in the writ petition, no prayer is made, no challenge to the policy, but by way of a CAN application, he is questioning this policy and asking for judicial review.
Not much submission has also been made on this application. Yes.
So, my lord, that also cannot be entertained. These are more humble submission.
State.
Support, my lord, KMDA, my lord. Yes, my lord.
No further submission.
No, my lord.
Some other day. Mr. Chakraborty.
My lord, only I am thankful to my learned friend that he has not controverted the judgment of this honorable court, division bench. Ask that I will, my lord, make submission whether the KMD was justified in asking for any penalty. And my lord,
Come back.
the suppression of material facts, my lord, the word suppression means, my lord, which I have not disclosed. But my lord, if my lord, I don't have some documents, and my lord, on the basis of some assumption and presumption, I have stated something. Maybe, my lord, it is wrong, but that does not amount to suppression, my lord. I will argue on this point also, because my learned friend has stated so many things, and my lord, the subsequent judgment, perhaps I have not, my lord, cited Tukaram Joshi. My lord, the Supreme Court judgment with regard to, my lord, delay. So far, my lord, land acquisition matter and other matters is concerned. My lord, perhaps I have not cited, because at that point of time, my lord, the question of delay, my lord, was not there. And so far, my lord, the challenge of policy, my lord, in the Damodar's case, the division bench, my lord, categorically held that yes, you have to challenge the policy. And my lord, unless they disclose that on that basis of policy we have demanded the penalty. My lord, I put this question: how can I know that there is a policy? And how, my lord, I will get the opportunity to, my lord, raise this question in the writ petition? So all these questions, my lord, I will take some time, my lord.
9th January.
9 January. Should I
Oh, let it be 12th
Should
January,
I-
not 9th. Yes.
should I place judgments on suppression of material facts?
Already
Why?
placed.
Already placed. Are কত দেবে গো?
The Supreme Court, there are so many decisions of Supreme Court.
If you want to, you can. I will not stop you.
I will hand over.
Heard
12 January.
12 January. Heard learned counsel for the KMDA. Paragraph, let the matter appear under the same heading.
না না
12th
বলবো না।
January 2024.
আর্গুমেন্টে দেবো দেখতে পাবো।
Reply
আর্গুমেন্টে দেখতে
on behalf of the petitioner.
হ্যাঁ না আর্গুমেন্ট এখন কেন বলতে যাবো আমি তোমাকে
Next.
আই এম ডিপলি আউট
এই নামটা দিয়ে দাও
The state let the matter appear. The state adopts the arguments canvassed by the KMD.
On the point of delay, my lord had occasion to consider in the case of Himanshu Mallik's. My lord, all these cases.
No, no, Tukaram Joshi subsequent
I have
judgment.
not
There is
stated that, my lord.
elaborately
Now.
stated, my lord.
Face the judgment for next.
My lord, my lord. I'm
Next.
Huh.
Item 14.
My lord, I am for the petitioner, my lord. The lordship earlier direction to file a report, my lord.
Sometime.
Opposition file report.
That's my lord. Typically, my lord. One order said that the petitioners were not ready to accept the money. And another order said
Rutika.
he is there in the position. So in case of
So why don't you come back with a report?
Yes, my lord.
report, my lord, there is some difficulty. As to the my lord, organically separation is there.
Item 14, my lord, I am for the state. You are for the state. So there is been appointed. You have never appeared for the state at all in this matter? You have never appeared for the state in this matter, but it has been heard several times and represented by Mr. Dev.
But my lord, there is the report also with me, my lord, and the brief is with me. Mr. Ashim Ganguly is reading the matter.
I do not know. The court doesn't want to get into this. But several other earlier occasions, Mr. Dev has appeared all throughout.
Just a minute, my lord. But my lord, report in the form of affidavit is like me, my lord, original one.
Then my lord, if you want, you can.
I do not know. I am not. The court will not get into this.
My lord, no copy has been served upon me.
My lord,
But the report is my lord, may I file the report?
My lord,
My lord,
one copy,
my
may.
lord,
Copy.
I will serve my report because there is no other copy. I will school have copy of number.
আমি 18 নম্বর করে
ওটা না আমার পাশে
ব্রিফের পিছনেই তো আছে।
You have not received a copy as
No, my lord.
My lord, I will serve in course of the day because there is no other copy. I will xerox it and I will give it. It's a copy. And no other copies. My lord.
Then the petitioner may use an exception to this.
My lord, kindly pass the necessary order. My lord, my lord, record in. I will serve the
Affidavit submitted on behalf of the state respondents is taken on record. Stop. Copy not served.
My lord, kindly record. I will serve.
Paragraph. The state respondents are directed to serve copy of the report to the petitioner in course of this day. Paragraph. Shall I grant him liberty to use an exception?
Yes, ma'am.
Paragraph on prayer of the petitioner, liberty is granted to use an exception to the report if required. Paragraph, let the matter appear under the same heading on 12th January. Come.
24. লালাতন নেই তো আমি দিচ্ছি ওটা
15.
Lordship directed me to serve by the course of the day.
থেকে যাও না কেউ না Lord, I am for the petition. On the last occasion it was heard. Yes. Call for the report. My house has demolished without acquisition of land for expansion of road. Your lordship directed to take decision by the land acquisition collector. He has taken decision, passed an order, page 66. However, for the ends of justice, they decided that the executive engineer, Bedripur Highway Division, Etablity Road, is given a subject plot to measure and take a decision.
Yesterday, a report.
আমার ঘরটা ভেঙে দিলে রিপোর্ট দাও আমার টাইম
A positive decision has been taken in favor
Yes.
of the petitioner. Only that decision has to be implemented and a report submitted. Yes, that's the case.
Previously, they have given that there is no acquisition have been made. That I have also, they say, I have also annexed this matter. Page 48.
Yes.
Page 48 minutes, your lordship will find.
Let the
No.
state come back with a report.
This is the last chance.
Learned
Otherwise,
counsel for
restore my position.
State respondents seeks extension of time to submit the report. As called for. Paragraph, let the matter appear under the same heading on 11th December. 19th.
Well, the order is January 2022. 2 years have passed.
There is an order in favor of the petitioner. The executive engineer has to act in terms of the order. 19th December.
19 December.
Next.
18th of August, your lordship was pleased to hear the matter. And finally, your lordship held that the penalty order that I have challenged in the writ petition should not have been challenged because this has become redundant. And your lordship was pleased to pass this order that is not subsisting. But as the authority was not allowing me to conduct the lease, I challenged the order of penalty because they were threatening me until and unless I pay the amount, they will not allow me to continue the lease. So I wanted to file a supplementary affidavit, and they have served me a notice to that effect that you deposit the penalty amount, otherwise I filed the supplementary affidavit.
Have you served?
And I have service copy. I have annexed. But this was issued in respect of the writ petitioner, the item number 17, which she is my wife. I am conducting his business also and my business.
Item 17, I am appearing, my lord.
This is 16.
Yes, no, both same matter, similar matter. My learned friend is mentioning about item 17, that's why.
No, I'm dealing with 16 now.
May kindly turn to annexure SA1 at page 6.
That is not in connection with this writ petition.
No. Actually, I am conducting the
No,
business
that's
of my
not-
wife. And
Writ petitioner is.
Daran, I'm
before the
bolte dao
sub-
na. Bolte
Then
dao de-
this notice has been issued to the Savanti.
Savanti, that the next
How
writ
will
petition.
matter known?
So it will be dealt with in the next writ petition.
No.
Next writ petition.
They were also charging me that why I have not deposited the amount.
There is that document of charging you.
That is not served on me. But it has been served. I am as an attorney holder of the of my wife.
দাদা এটা কেস নয়
দাঁড়াও না আমি বলছি শুনতে দাও।
সুশান্ত শাসমল পিটিশনার শ্রাবন্তী
জানি তো।
দেখাচ্ছে, হবে কি
Where
করে?
is the power of
আরে
attorney?
বলতে দাও না আমাকে।
Where is the power of attorney?
Power of attorney, my lord, I have annexed in the writ petition. Power of attorney দাও নি?
This is not the case.
And this is served to the petitioner in the next matter, not this matter.
Not.
But my lord, they are charging me that until and unless I pay the amount, they will not allow me to continue the lease.
Where is that document charging?
That order has not been given to me, but
How
it has
is
been served in respect of my wife.
That is dealt
And
with in the
I am the power of attorney holder of my wife. That
Cannot
is why I made a reply.
How is it possible? There are two separate plots.
Yes, my lord, I agree that there are two.
A notice is served upon you. You cannot give a reply to it. Where is the notice to which you have
Then,
replied?
my lord, your lordship has already been pleased to hold that the order is not subsisting.
So the first writ
Penalty order is not subsisting. Now, my learned friend said that your lordship cannot pass an order to the effect when the penalty order has been waived. And I will not be able to get an order from your lordship to get the lease deed continued.
How?
এবার
You have only challenged a notice which does not exist. So how is your writ petition maintainable?
no, এবার I wanted to continue the lease.
Come to the prayer.
My lord, kindly come to page 10 of the supplementary affidavit.
Prayer.
That is the division bench order of this honorable court in a similar circumstances. When a penalty order was issued in favor of a leaseholder, then the honorable court hold that if the penalty order is not existing, the penalty order was set aside and directed the authority to allow the petitioner to continue the lease deed.
No.
For the lapse
What
period.
has been stated?
This judgment I have annexed in the supplementary affidavit.
Ground are different.
Same here, Madam, may I read out?
Where is the document disallowing you from continuing with the lease?
This is the matter.
You say that you are not allowed to continue with the lease.
That is not given to us. After demarcation, on the basis of judgment passed by this honorable court, the appellate authority, which is the district divisional commissioner, they hold that the measurement was not done as per process. So the authority directed the DLRO to complete the process in terms of the order passed by this honorable court in 2015. And that order has been passed in 2022. But even then, thereafter, they are not allowing me to continue the lease. Demarcation has been made, all in presence of all the parties. Demarcation has been made in respect of all the parties. At
Page 71, my lord. Your lordship, kindly turn to page 71.
81. 81 final order. My lord, 81 page. Page 81. The event of demarcation in compliance of the order aforesaid is successfully conducted with the unanimous admittance by the Sushant Satmal, Taraknath Janai, including all others. Thus, the entire reasons are taken into consideration and hereby joint inspection duly carried out is accepted and disposed of. The demarcation was made, but the order was not allowed to be continued. The lease was not allowed to be continued.
Why?
Lease was not allowed to be continued, which was stopped in 2015 March.
So why?
So what is the value of the lease? What is the value of this demarcation? Why should I fought the battle for more than 8 years? There is no whisper that I will be allowed to continue the lease.
Such case.
What was the direction of the court?
Your lordship,
My lord, several
direction of the court
before this honorable court. My lord, your lordship, kindly turn to the prayers.
Let me answer.
What he has challenged.
Let me answer the question.
What he has
What is
challenged.
the order of this court?
Prayer A read in the page 16 of the. A read in the nature of mandamus calling upon the state respondent for asking them to show cause as to why the honorable court did not kindly was the order demanding penalty dated such and such. Issued on 29th May 2015 and 11/12/2005 and so forth as to why they will not be allowed to the petitioner to continue lease for period of 3 years or 10 months. That notice was challenged before this honorable court, my lord, earlier. And this honorable court was not entertained that writ petition. Your lordship, kindly turn to page 40.
My learned friend is not
Page
correctly
40.
submitting. After prolonged hearing, your lordship was pleased to hold that that penalty order is not
Page 40,
existing.
Annexure P8. It was moved before the Honorable Justice Sanjeev Banerjee. The petitioner complained.
No, that order is not.
29th May 2015. That was challenged, my lord. That is the prayer. Once it has been challenged, the Honorable Court decided the matter. Again, he has come before the
No,
How
no.
it is maintainable, my lord?
No. Your
Yes, page 40, this notice was challenged.
Yes.
my lord,
Page 40.
40.
And it has been elaborately decided by my Lord Justice Sanjeev Banerjee. And his lordship was pleased to hold there is another provision for appeal.
And she has preferred the appeal, and that has been decided also.
Yes. Thereafter again, the honorable court directed me, granted me liberty to prefer the appeal before the division. আরে আমাকে বলতেই দেবে না তো আমি কি করে বলবো? আপনি ভুল সাবমিশন করবেন আর কোর্টকে বুঝাবেন। This is not fair. This is not fair. This is not fair. Honorable Justice Sanjeev Banerjee was pleased to direct me to prefer the appeal before the appellate authority. That appellate authority has been changed. After 2016, the new rule has come into force. Then Honorable Justice Bagh was pleased to direct me to prefer the appeal before the divisional commissioner. Yes, yes. That order that was decided. My lord, kindly come to page 60.
60.
Page 60. Appeal was decided on 28 May 2019. In page 1, the authority was pleased to hold the writ. Has your lordship got it?
Yes, yes.
My lord, I am reading the last paragraph. This writ petition is disposed of by directing the respondent number 4 and 7 to issue a joint inspection of the total area concerned and demarcate the area of the long-term lease, mining lease. The authorities are directed to see that the respondent number 14 or the petitioner may not disturb each other's peaceful possession of the lease over their respective leasehold lands. The demarcation of the respective areas shall be completed within a period of 8 weeks from the date of communication of the order, upon serving prior notice to the holders of the respective. How does it say that the honorable court has not entertained the writ petition? This is the honorable court's order. The authority reproduced. Then, my lord, what happened? The authority says, kindly come to page 61 at the last paragraph. Thus, it is clear that all concerned parties were not involved in the joint inspection, as directed by the Honorable Calcutta High Court in this case. Then, my lord, decision. Hence, it is apparent there is apparently an inherent lacuna in the process. I therefore direct the ADM DLR of Paschim Medinipur to carry out the joint inspection afresh. On reading this, your lordship was pleased to hold that the penalty order has become redundant. That is why your lordship passed the order on 18th. Kindly peruse your lordship's own order. Your lordship will find it.
The notice issued on 29th May 2015 was challenged by you before the appellate court.
Yes.
So how can you challenge the same notice before this court?
No, I am not challenging the same notice. The penalty order they are demanding in my wife's case, expecting that. Yeah, I have also been penalized on the same notice, on the same date of notice. They have issued the demand notice to my wife.
Sir, please forget about your wife in this petition.
Achha.
Please speak about yourself.
Yes.
The wife will be
now, on the basis of this, they did not do anything, demarcate the land. So I again came to this honorable court.
A says, why this honorable court will not kindly quash the orders demanding.
Yes, my lord, that is my prayer.
On 29th May. This order was already challenged earlier.
As the authority is holding that the penalty order is remaining in force, they are not allowing me to continue the lease. That is why I challenge this.
The order was challenged. Page 40 is the judgment order of this court. The same order was challenged before this court earlier, and an order was passed.
This finally the authority decided that
So how
the
can you
order.
challenge the same order again?
No, but the order was not quashed. Measurement taken on the basis of which the order was passed. That measurement was decided as bad.
The order could not be done by
That
this court.
on the basis of that, your lordship was pleased to hold that order has become redundant, or your lordship has been pleased to hold that the order is not subsisting.
Yes, there is no such notice.
Now I am not challenging that order. I am coming before this court. I have come before this court after the demarcation was made in 2020-22 at page 81.
Where have you stated that in your writ petition?
81. 81 is the final order. Demarcation was made. But I was not allowed to continue the lease. When I went to inquire in the office, they said that until and unless you clear the penal amount, your lease deed will not be allowed to continue. That is why I have challenged that penalty order. Otherwise not, I would not have challenged.
একটা নোটিশ চ্যালেঞ্জ হয়ে গেছে আবার সেকেন্ড টাইম থেকে চ্যালেঞ্জ হয়
আর চ্যালেঞ্জ করছি না তো।
প্রেয়ারে যে লেখা আছে বাবা
প্রেয়ার তো ডিলিট করা যায়, অসুবিধা কি আছে? প্রেয়ার করতে না পাস করতে পারে, আমি চেয়েছি প্রেয়ার। এইবার আমি নেক্সটটা দেখাবো তোমাকে। নেক্সট রিট পিটিশনে কি হচ্ছে, সেম কজ অফ অ্যাকশনের উপরে ওনার পেনাল্টি অর্ডার করছেন। আমি যেহেতু পাওয়ার অ্যাপার্টমেন্ট হোল্ডার, আমার বউয়ের নামে করেছে, তাই আমি করছি।
এটা নয় সেটা
দেখাচ্ছি, দাঁড়াও না, পরেরটাই।
পরেরটা তো আমি নেই
ব্যাস নেই তো নেই, একসঙ্গে সাইমালটেনিয়াস অ্যাকশন হয়েছে তাই বলছি।
আলাদা কেস।
Actually, the lease of my wife and my lease deed is adjacent land, same area, same bed, adjacent lands. Two areas has been given to us.
Why has your lease been stopped?
Huh, my lord?
Why has your lease been stopped withheld?
My lord, he has excavated the land which was, my lord, allowed to, my lord, to excavate. A measurement has been done, my lord. Your lordship kindly turn to page 33.
আবার সেই measurement, that measurement has been
যত জানতে চাইছেন দেখাবেন না, যত দেখি রে ভাই।
One temporary permit holder,
Clear about your
my lord, one temporary permit holder was allowed to excavate sand
yes.
within our areas, and he was extracting the sand, and that offense was thrown upon us. That is why the measurement was taken in our absence.
Your lordship kindly turn to paragraph page 34. Demand notice.
Yes.
আবার এটাকে রিভাইভ করাচ্ছে।
That is the notice, my lord, which he has challenged.
Yes.
That and that is the prayer. Where it
Is that
demand
the
notice,
next
where it appears that you are mining leaseholder such and such, during joint is inquiry on such and such, it has come to the notice and undersigned that you have extracted the sand amounting rupees such and such 60 feet river bank in both sides of the river as well as from the outside of the lease area, hold area. This such unauthorized extraction contravenes the provision of section 22 of the minor minerals development such and such and rule 33 of the West Bengal minor mineral rules. 10 times penal price such and such, sand rupees 11,06,500 only. In view of the, you are directed to deposit such amount. That has been challenged before the honorable court in the earlier writ petition.
Yes.
And
In 2015.
Sanjeev Banerjee has been pleased to decide.
No,
Thereafter,
that was not decided.
One,
Bhattabhadai, will you please come back with a comprehensive report?
my lord,
Because
My lord?
I cannot follow what is happening.
yes, yes, yes.
My lord,
Yes, my lord.
let me
Your
clear
lordship
it.
is correct.
He is confusing. He is confusing. There are 6 writ petitions.
Actually, I
There are continuously 6 writ petitions has been filed.
Sir, come back
In
with your
2015, first writ petition. Then after the penalty or measurement was taken up, I filed a second writ petition.
report. সেটা অন্য
Then
কথা।
Honorable Justice Sanjeev Banerjee was pleased to direct me to prefer the appeal. I preferred that appeal. Appellate authority uphold the order passed by the authority, district DLRO. Then I again challenged that order, appellate order.
তোমার জমিতে
দাঁড়াও না রে বাবা, এই তো বলতে দেবেন আমাকে। Then again I challenged that order. In this, that order was held by the Honorable Justice R.K. Bagh. That appellate authority is not functioning at the present state after the rule has been changed. 2016 rule, it has changed and the appellate authority has been changed. The divisional commissioner has become the appellate authority. So I was directed to prefer the appeal before the divisional officer. The divisional officer finally adjudicated the appeal in 2019.
Where is Justice Bagh's order?
That order I read out just now.
No, I want the entire order to be.
What?
The entire order of Justice Bagh.
This order was at page 60.
Portion of it, part of
The Honorable Justice R.K. Bagh. Prior to that, kindly come to page 58. Last page. Last page, page 58. Honorable Justice R.K. Bagh.
58.
Huh?
Page 58.
Page 58. I am taking to your lordship to This is the worst. No, page 58. Page 54, the last part. I read out from page 53.
Give me a minute, please.
53. The factual dispute raised by the petitioner in connection with the joint survey made by the respondent number 4 cannot be decided by the writ court. On perusal of the provision of Rule 62 of the West Bengal Minor Minerals Concession Rule 2016, I find that the West Bengal Minor Minerals Rule 2002 has been repealed with effect from 19th July 2016. But any action taken under the old rules or any transaction stated under the state rule would be deemed to have been validly done or started as the case may be under the corresponding provision of these rules. The appellate authority is under obligation to follow the provisions of Rule 62 of the West Bengal Minor Minerals Concession Rule in deciding the appeal referred by the present petitioner. Since the divisional commissioner is the appellate authority under Rule 51 of the West Bengal Minor Minerals Concession Rule 2016, and since the appeal is considered and disposed of by the respondent number 2, Principal Secretary to the Government of West Bengal, Department of, I would like to set aside the order passed by the respondent number 2 on 1st December 2016. Accordingly, the impugned order dated 1st December 2016 is set aside. The petitioner is at liberty to prefer the appeal before the divisional commissioner under the Rule 51 of the West Bengal Minor Concession Rules. This are on the basis of this liberty granted, I prefer the appeal before the divisional commissioner. And the divisional commissioner decided the issue after the Honorable Justice Harish Tandon was pleased to direct them to comply this order, decided the issue on 28 May 2019 at page 60, annexure P10.
So this appeal has been disposed of?
Yes, holding that the measurement was illegal.
And then fresh measurement was done.
Then fresh measurement has been.
Fresh hearing, fresh measurement, fresh demarcation in terms of the order passed by this Honorable Court in 2015. That is Honorable Justice Sambhuddha Chakraborty. Or that order was directed to be followed. That was also not complied. Then again I filed a writ petition before the Honorable Justice. Yeah. Before the Honorable Justice Nijamuddin. Then they started making process of finalizing the demarcation. And ultimately, at page 80, your Lordship will find that the demarcation was conducted. 81 is the final order. Page 81. After perusing all these documents, your Lordship was pleased to hold that a penalty order was not existing. That is why your Lordship passed that order to that effect.
That is existing.
Order says so.
What is the result of the demarcation?
Nothing. Thereafter, they remain silent. They are not allowing me to conduct the list deed or continue the list deed.
Let the state come back with a report.
My lord.
After all this happened, a fresh demarcation took place. The petitioner says that they are not responsible for the illegal extraction. Some other person has come and done.
No, this is not correct. Huh? Paragraph 3, my lord, what he has stated. One, Tarok Jana was an leaseholder.
Right.
He, my lord, encroached his portion.
Yes.
Accordingly, he approached before this Honorable Court, preferred an application. And pursuant to the Honorable Court's order, joint inspection has been made. And it has been found that
I am
they
guilty.
are not satisfied with the demarcation.
I am guilty.
Demarcation.
Where has it gone from?
First demarcation, my lord, set aside by this honor. Next time, my lord, demarcation has been held. And it is, my lord, page 70 started. 71 states, here, Lord, kindly see. Declaration. Mohammed Uচ্চ আদালতে WPA number such and such.
Page 71.
71.
Yes.
মহামান্য উচ্চ আদালতের WPA 15809 2009 2019 এর অর্ডার শাসনসার আদেশ বলে নিম্ন স্বাক্ষরকারী তথা আবেদনকারী আমরা নিযুক্ত চতুর্সীমা ডিমার্কেশন আমি দেখিয়া বুঝিয়া পাইলাম যাহা সত্য বলিয়া গ্রহণ করিলাম স্বাক্ষরকারীগণ first signatory is the petition.
So what is the result of the demarcation? Where is the demarcation report?
Next minor, next please. Report of joint.
Prove that I was guilty.
Yes, you.
So your document that I was finally held guilty. তুমি বুঝাচ্ছ ভুল আমি বুঝাতে বলবো না
But this is not the result. It is only said that it has been demarcated.
Regarding encroachment.
Now, whether, yes, that is not stated in the report.
It is not his that case, my lord. He first earlier moved this writ petition challenging the notice, demand notice dated 29th May 2015. That has already been decided and by the appeal has already been disposed of. Again, he has come before this committee. It will be better, my lord, I shall come back with a comprehensive.
Because he is not allowed to continue with the
His period is already over, my lord.
Yes, he is asking for the lost period.
Yes.
But as he is asking
Yes.
for the lost period,
No,
but
no,
he
it
was
is
not
not
able
correct,
to.
mother.
I have been granted the lease for 5 years. I ran the lease.
Granted in the year 2012. Thereafter, just continue.
I ran the lease for only 1 year, 3 months.
15, it was granted for 3 years.
No, 5 years.
Let the state come back with a
Come there,
comprehensive
it will be better.
as to what has happened after this.
Yes.
The result of the demarcation and the appeal. You have filed a supplementary affidavit today.
Yes.
Supplementary affidavit filed by the petitioner is taken on record.
Thank you.
Paragraph. The petitioner prays for a direction upon the respondents to allow him to continue for the lost period of 3 years and 10 months. Stop. Paragraph. Learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph. Let the matter appear under the same heading on after vacation.
My lord.
After vacation.
And I am suffering for 8 years. Kindly consider that point.
1 week after the vacation.
9th January.
I have no objection, but I am suffering for 8 years. Kindly consider that, man.
9th January.
Now, what he will say about the second writ petition?
The same similar matter, my lord.
Similar matter নয়।
I am
এখানে তো আমাকে পেনাল্টি নোটিশটা আবার ইস্যু করছে।
Yes, my
Let her say, yes.
My lord, I am filing the supplementary.
Oh, there are
Pension matter.
Well, wait.
matters are there.
This supplementary, only I go, I'll take your lord.
Let it be taken up on the same date.
Yes.
Will you come back with a report in this case
Yes,
also?
yes, my lord. I have some instruction with report, my lord, not in the form of affidavit.
Come back in the form of an affidavit. Because it's the same matter, isn't it?
No. Here the penalty order has been issued again.
I hand over the report up to date, which is
not
with me. All right.
Here the
All right.
penalty order has been issued again.
As your lordship, please.
Same order in
As
this
your
matter also.
Must be supplementary affidavit allowed.
January.
Same order. Same order, same order. Supplementary affidavit বলেছি না?
Oh, right.
Yes. 188.
Here the penalty order has been issued.
Please come back with a report in the form of an affidavit on the next day, stating the entire facts. It should be
All
a
right.
comprehensive.
All right. All right. As your lordship pleases. Deeply obliged, ma'am.
Mention matters item 418.
Item 17 also.
418 তোমরা আমাদের নোটিশ দিয়েছিলে? আমাদের briefing
418.
418
Mention matters.
I am for the petitioner matter.
for the state reference, my difficulty is that I have no brief.
My lord, my difficulty will be, my lord, that there is already a notice for demolition, my lord, of the structure. Now, my lord, only
It has been mentioned. তোমরা নোটিশ দিয়ে মেনশন তো দেখো
Yes, there was a notice.
ঠিক আছে ও আচ্ছা ঠিক আছে ঠিক আছে এটা আমাদের বিল চেক করছি না খুঁজে পাচ্ছি না
My lord, may I only draw your lordship's attention to two for factum, my lord. My lord, kindly takes up page 42 once. My lord, this was a previous writ petition, my lord, filed by me. My lord, challenging a notice, my lord.
42.
42, my lord, annexure P9. This was a previous writ petition, my lord, filed by me challenging an notice, my lord, under my lord, section 10, sub-rule 1, my lord, of the West Bengal Highways Act, my lord. Now, my lord, kindly considers, my lord, the direction passed, my lord, the second paragraph, my lord.
Yes, sir.
Considering the submission of the
No
petition.
such operation, no such opportunity was granted to you.
My lord, the difficulty is, my lord, the direction was on respondent number 2 and 3. Now, my lord, the respondent number 2 and 3, who is, my lord, kindly, my lord, lordship, turns to page 43. 44, lordship, to be precise.
Mr. Bandyopadhyay, shall I make it not today? Yes, this is brief today.
My lord, but in the meantime, my lord, no coercive steps, my lord.
Not today only, come back tomorrow.
Tomorrow, my lord.
Did it not today?
মানে ব্যাক ইন করতে গ্রেট কাম করে দেবো ঠিক আছে
419.
State respondents.
I appear for the KMDNs.
May I find the affidavit of funds?
Private respondent.
Who is appearing?
Lord, I am appearing for the private respondent. 7 and 8. Principal respondent.
My lord, the subject matter of the writ petition pertains to my lord that
Who is appearing for the state? No one. Served.
my lord, affidavit of service.
Lord, before my learned friend starts, my lord, it is our duty to point out, if you also kindly cease the prayer, I think it relates to group 9 matter.
No. But it is not the RTA, but any information under the RTA Act. May I place the factual aspect of the case, my lord? Because, my lord,
Prayer B.
the
Prayer B.
illegalities, my lord, effectuated by the KMDA, that has been, my lord,
How is it maintained before this court? Prayer B.
B. It's our duty, my lord. If any order is passed, either of the party,
no, my lord, may I
it would be very
my lord,
difficult for us.
whatever the illegalities, my lord, that has been done, my lord, the KMDA. My lord, I, my lord, like to place on record because, my lord, this is the.
You are asking for a fair and accurate information with regard to the acquisition.
But it is not the Right to Information Act. Because, my lord, a civil suit is pending between the parties. There, my lord, a question of acquisition of 10 decimal of land is a vital issue, my lord. Now, my lord, the KMDA in different places place different information. Even, my lord, they have placed those documents before this honorable court, before the landed court below. So, my lord, I like to place on, I to submit before lordship, what are the, my lord, the illegalities that have been committed by the, my lord, the KMDA.
But you say that a civil suit is pending with regard to the same subject matter?
Not same subject matter.
Yes,
Same subject matter. My lord, not same subject matter. Put for declaration, my lord, that we are the legal owner. There, my lord.
Over this issue, my lord, matter is pending, judgment is delivered by the district judge.
Let me say, several
So the same 10 decimals of land is involved in the writ petition?
My lord,
you have prayed for declaration in respect of 10 decimals of land.
Yes.
Not title.
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 Yes.
Not my lord, only.
So let your title be decided. How can you proceed with the writ petition?
From the record itself, my lord, lordship can have a look to the, my lord, documents.
Declaratory suit is pending.
Not with regard, my lord, declaratory suit, my lord, with regard to the, my lord, property which you have invested.
With
Lord,
the same
kindly look to
decimals of
page
land.
8 only few lines. Page 8, my lord. Eta din na.
10 decimals of land which
Page
is
8,
involved
my
in
lord,
the
of the
petition.
judgment. Lordship,
Same
kindly look it.
My lord,
Page 8, my lord, will answer.
Yes, how
So-
will both go simultaneously?
No, my lord, kindly appreciate. My lord, kindly appreciate. I am not, my lord. I am.
Page 8, my lord, middle.
My lord,
Lordship will
if
answer.
I am not in a position to.
Let it complete.
This is Mr. Banerjee. That's everywhere.
Yes, please explain. The same parties in the suit?
Parties are same in the suit.
Yes.
Well, I cannot deny that the parties are the different, my lord. My lord, only thing is, my lord,
And the vesting of 10 decimals has also been dealt with by the court,
by
the
the,
civil court.
but that has been there, that has been, my lord, pleaded. That has been pleaded. But my lord, due to my lord the information or my lord the factual aspect.
So you have to prefer an appeal against the judgment. Writ court will not intervene.
No, my lord, I am not on that. I am, my lord, I have already prepared the appeal or revisional application, whatever may be, my lord. Here, my lord, kindly, my lord, see some documents. If your lordship will find,
How
my
can
lord,
the writ court intervene
my,
when the
if,
suit is
my
there?
lord, if your lordship, my lord, finds that there is no merit, your lordship kindly dismiss my petition. But my lord, kindly,
Question of
my lord,
merits at all.
my lord,
This court will not intervene at all.
no, my lord, the illegality is conducted by the, my lord, the KMDA.
You'll state
It has to be, my lord, the, my lord, the violation of the principle of natural justice. Because KMDA public authority.
Illegality on merits is not a violation of principles of natural justice.
No, my lord,
I'm sorry.
KMDA is a public authority.
Yes.
KMDA is a public authority. KMDA must, my lord, perform their statutory duties to, my lord, render the actual state of affairs. My lord, KMDA cannot act at the instance of any.
The exact subject matter is stated in the judgment. The same issue, the same subject is in the. Is
I have not, my lord, subject, my lord, I have stated.
So this court will not intervene.
I have
I'm
stated,
sorry.
I am not on that 12, my lord, 10 decimals of lag, my lord. I am not on the 10 decimals of lag.
Come to your prayer portion, please.
I am on the, my lord, the illegalities committed by the.
Please come to your prayer. First prayer deals with correct information. This court cannot deal with this prayer.
Yes. We also say same.
Second prayer is also connected with acquisition, which has been dealt with by the trial court.
Ground number 18, my lord. Ground number 18, 10 decimal.
No other prayer.
Yeah, see.
My learned friend is submitting, alleging against KMDA. If your lordship sees, where is the allegation in the petition?
It's not there in the writ petition.
And more so, annexed P3, lordship will find the document issued by the state authority and the next document issued by KMDA. How there can be allegation against KMDA after these documents?
Prayer C of the writ petition has been dealt with in the title suit.
Absolutely frivolous.
And Lord, page 8, my lord, of the judgment. Only few lines.
I've seen that.
Lord, answer is there, my lord.
I've
That
seen.
answer is given. Lordship. Answer is given. Lord, his remedy is to prepare revision before this honorable court against that order.
No, my lord,
Lord,
that,
that court held that this question will be decided in the trial. Therefore, there cannot be any parallel proceeding
that I will, my
over
lord,
the same subject matter.
that I will, my lord, prefer the revisional application.
Yes.
But my lord, kindly have a look to, my lord, the document. My lord, kindly have a look to the document, my lord. My lord, just a minute, my lord. My lord, kindly page 35, my lord. Kindly have a look, my lord, page 35.
That I am showing 34 and
Chakraborty, we are only wasting time. I
That
must
is
say
38, my lord,
My lord,
2019.
illegalities, my lord, if the, my lord,
Where is your prayer in the writ petition about the illegality of the KMDA? Please show me
but
one.
I have pleaded in the writ petition. My lord, what would be the my relief, my lord? My lord, what would be my relief? I put this question to myself, my lord. What would be my relief? My lord, kindly have a look, my lord, page, my lord,
Prayer C has been dealt with in the judgment. You agree?
my lord, that is, my lord, with regard to that, my lord, the
With
acquisition.
regard to anything, I'm not concerned. Prayer C is dealt with in the judgment.
That is, they are dealt with
Yes.
judgment.
Prayer B cannot be entertained by this court.
My lord.
So what is left in your writ petition? Is there any other prayer?
But in that event, my lord, because
Dismissed only on this ground.
my lord, then my lord, leave be granted to file, my lord, file
File what?
because my lord, the record shows that the my lord, it
Yes,
is, my
that
lord,
has been dealt with by the civil court. The writ court will not interfere.
well, in that event, my lord, I put this question to my babe, that my lord, the KMD, what the KMDA rendered, my lord, the information, wrong information, and my lord, misleading information, that has to be taken into consideration, has to be true.
That has to be dealt with by the civil court who has dealt with the issue, not
No,
by
my lord,
this court.
I put this question to myself, my lord, the illegalities which have been committed by the KMDA, well, that will be considered as to be, my lord, the genuine
Have
one.
you stated this before the civil court?
My lord,
Have you stated this before the civil court when it was heard?
Yes, all these points are, my lord, because they place this because before,
Legality of the KMDA, have you
my lord, they have,
submission before the civil court?
my lord,
And in this writ petition also there is no such pleading.
yes,
No
yes.
such grounds is
No, no,
there.
Paragraph,
that has been pleaded, my lord.
paragraph,
Where is the illegality committed by KMTA in furnishing information?
paragraph.
My lord, paragraph 18, 19, my lord.
Two different letters of the KMDA. Where is the illegality?
What is the illegality? It is not affected by
Because, my lord,
That's
with
what
regard
we
to
have said.
the self-same DAG number, my lord, once they are saying that it is not affected by any LA proceeding,
When the issue was dealt with by the suit court, you should have submitted this before the suit court. That there are two contradictory notifications.
my lord, I
letters.
bow down to your lordship, my lord.
This is not contradictory. One
My
thing
lord,
may I
bow
show.
down to
When
your
my
lord-
learned
my
friend
lord,
is saying,
my lord, but my
kindly
grievance is, my lord,
compare page
my
35
grievance is,
with
my lord, not to adjudicate whether
with
it is,
38.
my lord, vested or not vested, not that.
This
The prayer says that.
Only the information, my lord, correct information, true information.
Can that be done by this court dealing with the land jurisdiction? Approach the appropriate forum. Correct information cannot be given by this court.
My lord, many things has been said by my learned friend. Lord, kindly compare page 35 with 38. Where
38 will give the answer.
have we changed our stand? 35 and 38.
Yes.
Where? Not
My
affected
lord,
38.
35 have stated that 0.58 acre out of 0.68. And in the page 38, the entire tag number has been stated that not affected by KMDA.
You have sought for information, we
Why
have
is that,
supplied
my
the
lord,
information.
10 of time? My lord, it is 0.58 out of 0.68. They have not stated that 0.68 is out of acquisition, beyond acquisition. Now the entire DAG has been, my lord,
This is
certified.
Page
that it is-
35 is the information supplied
Yes,
on the
it is
on the basis of the
it is
RTA
on the basis of
application.
the entire tag number.
If you are aggrieved, you
Page
could have
38 says the entire DAG.
entered that.
And page 35 says only 0.58.
Yes.
Because, my lord, when this was given at that time, my lord, 2012.
And not only that,
11.
my lord, kindly have a look to page 42.
34, my lord.
My lord, kindly have a
2011.
look to page 42. My lord, kindly have a
But,
look
my
to
lord,
page
they are the
42.
requiring body.
What they have stated.
Acquiring body is the collector. Collector
No, my
says
lord.
lapsed.
My lord,
Acquisition is lapsed. Because possession was not taken, compensation was
So
not
this
given.
was dealt with in the judgment, in the.
Yes. That question cannot be decided. Not
Yes,
parallel
what do you suggest, Mr. Chakraborty?
My lord, then my lord, it be granted to my lord to file a press so that my
For the
proper
appropriate forum. I can grant you leave to approach the appropriate forum for redressal.
if my lord proper relief is spread before your lordship, my lord, so that my lord I can
No
I
leave
can-
can be granted if he is permitted under the law.
No, not same cause of action.
No relief, no leave is required if it's a different cause of action.
Different cause of action.
Leave is required only if it is the same cause of action.
My lord.
With this cause of action, you cannot succeed.
No, my lord.
So it will be a fresh writ petition altogether.
My lord.
You can only withdraw.
If law permits, then he can do it.
My lord, an appropriate forum.
Learned counsel for the petitioner seeks to withdraw the writ petitioners seeks to withdraw the writ petition and approach the appropriate forum for redressal of their grievance. Paragraph in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no order as to cause, urgent certified website copy, affidavit of service to the
Appropriate forum, my lord, if permitted under the law.
petitioner knows. I do not.
Otherwise, you will show this, the High Court has granted me leave.
If the forum is appropriate. Next.
Now, to me, I could ask for correct.
Okay.
But may I be permitted to take back the copy?
Judgment and copy to fill. Next.
KMT party. No.
420.
Well, I beg to approve the petition.
তোমরা আমাদের নোটিশ দাওনি তো না দিয়ে করে দিলে
হ্যাঁ নোটিশ দেয়নি
না আমার যায়নি
কাকে
চন্দ্রগুপ্ত আছে বন্দ্যোপাধ্যায় করে আচ্ছা ও তো হলো আমি কোথায় আমরা কি বানের জলে বেশি এসেছি
না না বানের জলে ভেসে আসবে
মনে হচ্ছে
না তুমি কি
Fourth respondent is the state.
my lord
Who is appealing to this matter?
they have mentioned by how
টাইম নেবে বলো
না টাইম নেবো না করো এই অ্যাপিয়ার যখন করছি তখন টাইম নেবো
Mr. Shishana Bandyopadhyay.
Mr. Bandyopadhyay is my for the respondent number 4. Commissioner,
But I appeal for WB Hitco.
I am for the state.
So who is the fourth respondent?
The last
The corporation. He wanted to come back with a report. Where is Mr. Bandyopadhyay? He is not appearing in any of the matters before this court. You are for the state? Let us proceed. Yes, what is the matter about? I cannot wait for him in every line.
Here, the subject matter parties to the petition, well, the petitioner for the purpose of setting up commercial activities purchased, my lord, huge plot of land in the Moja Kulve area. Well, at the time of purchasing the land, my lord, CS record, RS record, and the LR record shows, my lord, most maximum, my lord, the land covers the classification of sun. Only a few portion, my lord, was, my lord, that is what recorded as, my lord, water. Not the end. No, my lord, all of a sudden, my lord, the entire area has been declared as wetland.
As?
Wetland. The entire Munja, all the dark numbers purchased by the petitioner, that has been, my lord, declared as, my lord, wetland. Now, my lord, kindly have a look, my lord, annexure P2, page 197. Man, there are those several purchase deeds are there, my lord. I will not trouble your lordship, my lord. Going, my lord, my lord, page 197, my lord. That is, my lord, mutation certificate granted by the BLRO in favor of the, my lord, petitioner.
Yes.
Now, my lord will see that in the mutation certificate, it was obligatory to, my lord, the record the classification of the land, but that has not been, my lord, stated. Only, my lord, total 4.7 acre in plot number 52, 521, 54, 554, and 674 has been referred to, and the mutation was done. Now, my lord, kindly have a look. Page 199, page 199. That is, my lord, drag number, CS drag number, my lord, 571, 572. This was purchased by the, my lord, the petitioner. One was been classified as Danga, and the other has been classified as Saj. Thereafter, my lord, page number.
No, but your plot numbers are 520, 521, 554, 674.
Yes.
These are the 4 plots.
Well, these are all, my lord, LR and RS. LR and RS, my lord, because CS, my lord, different.
Yes.
So your lordship, my lord, that CS is different, my lord, because the land, my lord, the classification of the land, my lord, originates from the, my lord, firstly from the CS record. But if the CS record is, my lord,
Page 197 is LR.
(197) is the, my lord, mutation certificate. LR.
LR. This
RS,
is LR.
LR. RS and LR.
No, no, these are LR numbers, LR
LR
numbers, yes.
LR number. And what I am showing you, Lordship, that are all my lord CS dark numbers, the previous dark number.
Yes.
Now, my lord, on 2000, page number 202. That is, my lord, only the dark number 679, which was renumbered as 674 in the LR. That is only, my lord, recorded as bill. Out of the purchase of all the dark numbers, my lord, only this dark number was recorded as, my lord, bill. Now, my lord, in the RS record, my lord, at page 207, although in the CS record it was, my lord, recorded as bill, but my lord, your lordship, can you have a look 207 page, dark number 674, that was recorded as, my lord, Sali in the RS record.
(207) dark number
674. My lord, this dark number, my lord,
yes,
was, my lord, 679, my lord, which was recorded in the CS record, that was, my lord, changed, my lord, as 674 in the RS record. So, my lord, when the petitioner purchased the land, it was classified as Sali. And it was, my lord, totally developed, filled by earth. The petitioner purchased the land. So, no part of the purchase land of the petitioner was ever, my lord, used for pisciculture or, my lord, any other for water, whether it was not waterlogged by any means, in any manner. Now, my lord, the entire land purchased by the petitioner has been, my lord, declared as wetland.
Mr. Chakraborty, will you continue on the next day? I have a division bench at 15. Mr. Kantapathy, your report.
Yes, my lord, I'm appearing for the fourth respondent, my lord, not for the state, my lord, for the
No,
corporation.
for the state, Mr.
Kantapathy is there, my lord. My lord, our instructions suggest that it is not falling under our area. But my lord, I'll try to get something in writing in the adjourned date.
Report today. Are you ready with it?
No, my lord, report is, my lord, it is not falling under our jurisdiction, my lord. If it is not falling, my lord, we will not have much to contribute, my lord, in the matter.
To come back with a report stating that.
Stating that, yes.
Yes.
On the returnable date, my lord, I'll come back.
But I appear for HITCO. This is not a land under the HITCO. HITCO has nothing to do with this, and HITCO is not an authority which would be granting any permission or not. No, no. It's not about.
It's the state.
So it's a state.
No, my lord.
BLLRO, because conversion or recording of any character of a land, it's nothing to do with HITCO.
No, no,
and it's not within the planning area of HITCO also. Not an acquired land, nothing.
The land has been declared as wetland by the state.
By the state.
No, my lord, in this matter, my lord, no conversion has been paid for. For that, another petition has been filed, which is also pending before lordship. But here, my lord, the HITCO is the authority to grant permission for development of my property.
Well, if it is a wetland, it will fall under East Kolkata Wetland Management Authority. They themselves have represented before that authority, but not made EKWMA as a party, as I find. But they, if your lordship sees the representation, they know who is the authority they need to approach. If it is declared as a wetland, it has to be declared as a wetland under the schedule to that act.
Yes.
But that authority is not before your lordship, as I find from the cost tax.
No, that is not another.
The representation was made to East Kolkata Wetlands. In the representation annexed.
No, my lord.
Made to East Kolkata.
No, that is another
Come back
letter.
some other.
Another letter. Another subject
But
matter.
learned counsels for the parties. Let the matter appear under the same heading on after vacation.
Sometime in February.
15 January. And the fourth respondent will come back with a report, not the others. On report is submitted by the fourth respondent on the agenda.
Before rising, my lord, where this time, my lord, I will be out of station.
Original side, item number 1.
This is my application. But I'll tell my lord what happened.
But I am seeking
Connection
leave
with-
to intervene in this matter. I am not a party in this matter. But what had happened before my learned senior friend proceeds, may I indicate in a minute? May I indicate in a minute, my lord, my locus? My lord, this pertains to a matter where the no, I am not, because today for the first time I have come to learn from this cause list.
File the application, then we consider whether it can.
Yes, but I'm seeking.
Before I make the
I
application,
I'm seeking for a copy of this application.
Not now, only after you get your locus, after that.
Because
File your application, serve copies to the others.
we shall, but only one
I think the application needs to be filed.
Yes, yes. I don't know who he is and nor do I recognize him. This is a matter which I'll presently explain. But in a winding up petition, this relates to a property. I'm asking for vacating of an order which was passed in 2019, and I'll tell my lord why I'm asking for that also now. In a winding up proceedings, this order has been passed. I, my lord, have a mortgage, rather I had a mortgage of over this property. It's a very valuable property in Worli, Mumbai. My claim in respect of the mortgage property was about 700 crores. Lord, I had also orders from the Honorable Supreme Court which says, yes, this property I could deal with as a bank. Lord, I'm ICICI Bank, Lord, and I could deal with, and Lord, sale could also be made. This property belonged, my lord, to a company, my lord, called Dunlop. Dunlop transferred to it originally, my lord, belonged to Dunlop. My lord, it got transferred, my lord, to other of its companies which had, my lord, then mortgaged the property. The official liquidator, my lord, came to challenge, saying that the transfer was wrong, my lord, to other companies. And my lord, in connection, my lord, in the winding up proceedings, we suffered an order which is really, my lord, purely an interim order, my lord, to say this property should not further be dealt with by me. Now, this was passed in 2019, my lord. The main application was pending. We thought, my lord, that will get over. Now, why I made this?
Still disposal of the matter by commercial court.
Yes, till my lord, disposal of, my lord, if my lord, I'll come to the order also. Till my lord, disposal of, my lord, the that matter, but now
Still pending.
matter still pending. Matter, my lord, sometime my lord, taken up, my lord, then it is still pending. But the difficulty is, my lord, under the Banking Regulation Act, and that is my urgency, the Section 9 provides that a bank can hold a non-mortgage property like this, if it's, my lord, if otherwise, my lord, for the purpose of banking, for 7 years. And the sale which was effected to me was, my lord, in 2016. Now, there's a provision for a further extension of, my lord, 5 years with when we apply to the Reserve Bank. But, my lord, the Reserve Bank, my lord, is really, my lord, quite naturally, my lord, they don't want to give extensions. Now, my lord, presently, my lord, we have told, my lord, only years. Recently, my lord, we got an extension of 1 year, but we want vacating because, my lord, a mortgage property cannot be the subject matter of, my lord, company court jurisdiction. Under the SUVRA Act,
That has been dealt with by the Division Bench.
no, my lord, it has not been dealt. It has not been dealt with. My lord, that is one of the grounds also why, my lord, I'm asking for vacating, my lord, of the.
Lord, may I file my affidavit
My
to
lord,
this? I appear for the respondent in this application and the appellant. It's my appeal. Yes, my lord, I have to file an affidavit to this application.
Appearing for?
I appear for the appellant and the respondent here in this application.
No, it's a question of law, but, my lord, I don't know, my lord, if they want to. It's really, my lord, a question of law, my lord, whether, my lord, that order would have been passed.
You're appealing for the bank,
I'm, my lord, for ICICI Bank.
the second respondent.
Yes.
And you're
Yes.
for the appellant.
I'm for the appellant.
It's really, my lord, a question of law because, my lord, we have, my lord, been naturally the order is, my lord, of some, my lord, and we have been waiting also, my lord, to have this, my lord. But I'll show, my lord, perhaps, my lord, that order at that stage, my lord, could not have been passed. Court did not have jurisdiction. That is also, my lord, one of the grounds
The matter
we've
is
asked for
taken
vacating.
within the next 1 year, that should suffice.
Yes.
My lord,
You place this order for the.
my lord, and my lord, the property is in a not, my lord, in best of condition. We are incurring expenses every day. 10 crores, my lord, already incurred, my lord, further on this property.
The primary point was the 7 years.
7 years, my lord, is one of the points. That is why, my lord, we have now come here.
Have you placed this before the commercial court?
No, my lord, that is, my lord, we are only restricted, my lord, by reason of this order. Otherwise, my lord, commercial court, my lord, I'm not, whenever, my lord, that
This
is
order
taken up.
again just
My lord, kindly looks at, my lord, the order.
commercial court.
my lord, just kindly, my lord,
Company
kindly
code
look
is in season of the matter. My lord, there are 3 applications pending before the company code concerning this property. And my lord, those applications are being heard from time to time. It is true, my lord, it has not been heard for some time now. But we can make a mention before the company code and it can be taken up, subject to the convenience of that court.
I don't mind, my lord, quite naturally, my lord. Whenever, my lord, that court, my lord, wants to take up, my lord, it can. I'm not, my lord, on that question. I don't want to, my lord, pressurize that court. But, my lord, the question is, my lord, the interim order affects me.
You're pressurizing this court.
No, my lord,
You can
I will.
approach the company and ask for an expeditious disposal.
Lord,
But the interim order is the disposal of the.
my lord, I shall show, my lord, perhaps, my lord, an interim order could not have been passed at all.
I cannot sit and appeal.
No, my lord, that's why, my lord, I'm asking for vacating of, my lord, that interim order or recalling of that interim order. And I'll show, my lord, orders of the Honorable Supreme Court as well.
Come back on merit with an.
Very well, my lord, whenever, my lord,
In the meantime, the intervention application.
my lord, if he wants to, my lord, kindly, if, my lord, if he at all.
Also seeking leave for intervention, and my lord, since I appear on behalf of West Bengal State Electricity Distribution Company, our admitted claim is 35 crores. So our interest is involved.
No, I'm not, nothing to do with West Bengal State.
It would be easier if the matter is disposed of by the court.
So a copy of this.
My lord, I will, my lord, just, my lord,
Intervention application.
my lord, intervention application, my lord, are not, it is only a question of, my lord, whether, my lord, the interim order will survive or not.
That have to be dealt.
My lord,
2 interveners already want to come
Lord,
intervention application.
I don't know, my lord, West Bengal State Electricity, my lord, has nothing to do with this. This property is mortgaged to me.
That has to be decided.
My lord, kindly, my lord, put it, my lord,
Come.
kindly, my lord, keep it next time, my lord, I'll, my lord, open. Since, my lord, he wants to file, my lord, he's at the appellate.
I would suggest please approach the company.
My lord, that, my lord, is a separate, my lord, issue, my lord, we will. But, my lord, this order, my lord, this order is hurting us.
It's connected.
My lord, my lord, the order of injunction is, my lord, hurting us. That's, my lord, the difficulty.
This court cannot sit in appeal over the order.
No, I'm not. My lord, I'll show, my lord.
You said it could not have been passed. That cannot be.
No, my lord, that's one of the reasons why I'm not asking for vacating now. Vacating also.
By the time we've taken these applications for intervention, the affidavit deal with it, I think the company court will deal with that. Finally.
My lord,
Let it come back. Let them.
my lord, kindly, my lord, put it, my lord, any day, my lord, when.
To serve a copy, otherwise we cannot.
After you join, sir, not before that.
My lord,
Application.
otherwise, without copy, we cannot file application for intervention without cost title.
That's not. Only if your intervention application is allowed, you're entitled to a copy, not before that.
My lord, intervention application cannot be.
On your own case, not on the basis of the bank's case.
My lord, in this matter, my lord, if I draw up the intervention application, then cost title is necessary. Otherwise, if the any copy of served to me, I cannot.
You can ask for it unofficially, the court cannot direct. Right. Unless you're added as a party, you are not entitled to a copy. I'm okay. Applications filed by the upon service of advance copies to the parties in counsel for the
There are 3 weeks, my lord, if your lordship kindly grants.
2 weeks, for
3 weeks, my lord, kindly.
You're appealing for one, as the appellant and the first respondent. Within a week thereafter?
Within a week.
Within a week thereafter. So that takes us to the vacation.
Yes, my lord. We can
Come back.
start, my lord, the new year.
11 January.
No.
Let the matter appear and
It's the constitution. 11 January. Lord.
I'm grateful.
Perhaps, my lord, it would have to be, my lord, some time. I don't know when, my lord. 2 o'clock. Grateful. Grateful.
Grateful.
Lordship, may I seek to mention this matter? Lordship, this is my writ against the WBIDC, Lordship. The dispute was regarding transfer charges on my property. Lordship, I was supposed to give my rejoinder submission. Lordship, the hearing was going on. There's no date that has been fixed, Your Lordship. Lordship will see the last order. This is dated 6th October 2023. Lordship, in between certain issues arose, they were writing certain letters, so this dispute arose, but the actual hearing of the writ, that got stalled. Lordship.
Yes, we had digressed actually because of this issue.
Lordship, but we need to,
Yes, right.
Lordship.
This issue has been set at rest.
Lordship, the letters are stayed, Your Lordship. No more letters have been served upon me, but the writ needs to be decided. Lordship. Lordship.
When will you come back?
Lordship, any date in December.
Despite, will you come back on in January, 11 January, the same date as I fixed?
No date in December, Lordship.
Because I have to write down a judgment, isn't it? I do not want to carry the judgment to the next.
Obliged, Your Lordship.
Yes.
11 January, Lordship.
Are you venturing upon notice?
Mal,
Item number 1.
Obliged, Lordship.
The only difficulty is that when the petitioner, petitioner only difficulty when this vehicle which
The vehicle is waiting.
was a long, my lord. Your lordship kindly see where
You say that you have complied with all the formalities.
yes, my lord, I have deposited fees even. Fees for permit that I have annexed, your lordship will find. That is a page 23. Right? This submission of documents along with the fees, that is at page 23.
Next Thursday, positively. Yes, ma'am. 30th of
Next Thursday,
yes, sir. That is 7 December. That for 7 December. Yes, ma'am. Learned Council for the state respondents. Learned Council for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 7 December.